Lord, by a resolution, Lord, they claim to have decided to sell the property to my learned friends because the original lord is Ashima. And all this is done behind my back, Lord. There's no notice to me. And also prior to that, the society itself had, at the instance of the direction of the retired judge of this court, Lord, convened a meeting and taken a decision to cancel the allotment, and that was cancelled. So all these things have happened after the cancellation of the allotment, after this company ceased to be in existence. The properties alleged to have been sold by the original allottee to my learned friend's client. In the second petition,
this Arfa, Ashima paid after the.
No, they did not pay. They paid to the society. They paid to the housing society. Yes, but the society did not accept the payment.
Oh, they didn't accept.
They did not accept the payment.
So the dues were to be paid to the society only.
Through me, because what the amount has to come to me, because these are assets belonging to the Sanchayani investments. These are assets of Sanchayani.
Go to the society, but through you.
Through me, yes.
This fact is not
so that amount was not appropriate.
No.
Not the amount because
and Lord, now sorry, I must point out. Now the dispute before this court is Ashima says I never sold it to him. They said we never sold. We never authorized. They have forged documents, etc. That is how he comes in.
It is not correct. The amount.
They have a sale deed of 5th July
2018, and before that, the amount was credited to the account of the society, and Mr.
You paid.
I paid, Milord.
You paid what? The dues.
Entire money, sale consideration, Milord.
Sale?
Maintenance, sale consideration, the balance amount.
You didn't pay to Ashima, you paid to the society. The sale consideration also.
Ashima authorized, Milord. Ashima authorized Mr. Anil Deshmukh
after the cancellation. After the cancellation.
Yes,
tell us
after the cancellation.
How can you pay it? No question.
The High Court has in 2000.
And where is this money now? What he says he has.
The society is kept it in a separate account. We had offered to return it to them because.
When was the actual cancellation?
Lord, the cancellation was the High Court approved the cancellation. Lord,
approval is another.
Yes, that was Lord, yes. That was on 9/12/2014.
Was that a proposal or was that
no? That was pursuant to the direction of the special officer by the retired court, the judge.
Where do we get that? Where do we get
that? Yes, document. My counter.
No, we'll just see that and thereafter have some.
Lord, my counter.
Have clarity on.
Yes, Lord, my counter to my learned friends SLP at page 79 to 82.
Counter of R3.
R4.
R4.
Yes.
R4.
The minute.
Lord, these are the minutes.
Yes.
Page?
Lord, page, if your lordship sees first page 77, that's the direction of the inquiry authority, that is the retired judge of this court. Lord, your lordship sees at page 77, these are proceedings of the inquiry officer dated 12/11/2014.
Yes.
And then, Lord, just over the page, the second last paragraph, on hearing it appears to me that it is a fit case where the representative special officer of Sanchayani and Investments India Limited, City Developers and Belapur's Cooperative sit together and at a reasonable and acceptable solution. I therefore direct the three parties to meet and sort out the issues so and so. Now, pursuant to this direction, on the next page, my lord, your lordship sees the minutes of the meeting of 8th and 9th of December.
Yes.
And then your lordship finds the relevant portion is at page 82.
Yes.
My lord, G.
Ashima.
Unit number 909. It should be 903. My lord, that's wrongly done. Being an allotment of so and so, etc., etc. And then, my lord, this particular allotment is cancelled. And then this cancellation
be cancelled as per inquiry.
Because the proposal
yes.
that it may
and then approved, my lord, and approved by this court at page 86.
This
is the minutes.
Sentence reads allotment be cancelled.
Yes.
Where is the resolution stating to
yes, no, this was placed and my lord at page 86.
So this is pass order cancelled as per honorable inquiry authority.
Pass order to cancel.
Sorry, well, just one moment. I'll just show that.
85.
85.
85, number
yes.
7.
Yes.
Recommendations. So Lord, this is also a recommendation.
Page 90. I'm sorry, well, page 90, the Calcutta High Court. Page 90. The last one, page 91 at the bottom.
Yes. What is the date of this?
My lord, this is dated 21st of July 2016.
2016.
My lord, page 91, the last paragraph.
Yes.
Under the circumstances, the recommendation captured in the minutes of the meeting held on 12th November 2014, that is accepted insofar as
Some 12th November.
clause 6 of the recommendation is concerned.
12th November, not 9th December.
No, that's my lord, I'll just show that. My lord,
Something else.
That was mistake, Lord, that was rectified.
that was rectified. That
That is 93, Lord.
that is
That is
rectified.
admitted position. That is 93.
So that's not rectified as 9 December. You can also find it at
I see.
page 93.
12th November is
Yes.
9th.
Rectified.
Yes.
Subsequent to that also there is order of Calcutta.
So, my lord, that 9th December is accepted. So those minutes are given effect to. So that's how the cancellation takes effect. So that is
doesn't require you to pass a separate cancellation order.
my lord, because the matter is being supervised by the company court, so we
Accepted.
we will, my lord, we are required to file a status report. That's
all.
mandate. That's all. My lord, otherwise it's a company court which has to take the final decision.
Issue of the recommendation. Execute the deed of conveyance.
What is 9th December report? After 2 years.
They make, Ashima makes the offer on 3rd June 2018.
Yes, my lord, in between, my lord, in between, before that, on 3rd of July 2017, Ashima Electronics is struck off the register of companies under 248(5). So that is a default, my lord, of non-compliance with filing reports, etc. The company ceased to be in existence, struck off.
Thereafter,
It was revived.
Thereafter, my lord, it was revived much later on. Now,
not at that point of time.
no,
letter was-
not when they made that offer, but the offer was made on 3/6/2018.
At which point of time it had been struck off the
It
yard.
was struck off.
Where do we find this striking off?
My lord,
Where do we find
that that was, my lord, that document is not on record, but they took out proceedings, my lord, for revival.
Where do
Where
you
is
say
that?
that?
Where is that at least?
That
might
is, yes,
indicate
I'll just
the
show
date.
that. That is, my lord,
You at least make a statement in your affidavit.
yes, yes.
Where is it?
Yes, yes.
Where is it?
It is there in the counter affidavit of R2 Miller. That is the
Ashima said.
Asima Electronics has filed the counter affidavit.
Counter.
To Charu.
R2's count.
Where is it?
R2's count.
Doctor's country. Which page? Number 5.
So this is the R5 Miller counter affidavit filed by R5.
Respond number 5. R5.
R5 or R2?
R5 is Ashima.
R4 is
R5 is Ashima.
Okay.
R5.
R2 is the society.
No.
So whose counter should we look
Society
at?
is
90.
society is
R5.
90.
R5.
So that is the
But we have placed that order on record.
That says 72.
So 3rd July,
Here.
Yes.
3rd July 2017 it's from.
Yes.
page 72 is the order of
That's the striking off. Yeah.
And revived on
Revival.
revived on 31st May 2022. Miller.
31st May 22.
Where do we get it?
This is in the
Same counter?
affidavit of R5 Miller.
R5,
R5 page 14 Miller.
page 14.
Page 14 R5 counter. Paragraph A Miller.
Okay.
In the
31st.
meantime, Mary Miller, in the meantime,
Whereby the response was revived. Very good.
72 to 70.
All right, 31st May.
it was revived in 22, and this application was filed by Mr. Anil Deshmukh with the authorization of Mr. Charu Agarwal, the director of the company.
So in 18,
So in between, Miller,
sale deal was seen to change.
Cindy. a sale deed?
That is in trade number, my lord, sale deed is. That is on page 78, my lord.
78 of the main papers.
Main paper. But that is not in dispute, my lord.
That is in dispute. They deny sale.
In February 2020, the Calcutta High
The
Court has.
sale deed itself is executed in the name of the company which is non-existent.
No. By the company.
At which point of time the company was struck off the ROC?
Yes, my lord.
It does
Where-
not have any existence at that time.
It doesn't exist.
2018, my lord, this was the law.
That puts you in.
Because
The
of
company is disputing the sale deed. It's executed when we are struck off. It is executed.
Well, you seem to have taken them also for a ride.
Nothing to do with the company and no money has come to the company.
Let us not,
That is
let us not be under any illusion. You are the main culprit here.
No, I'll indicate, your lordship. I represent the directors of the company. All this has happened behind our back. We learn and we immediately approach the court. Because not a single penny.
Well, how did you offer to make payment to R2 when you were not even in
The
existence?
payment offered to R2 is also at their instance. It's not at the instance.
How did you even do it when you were not
I
existing?
did not. Your lordship will just permit me when my turn comes, I'll indicate. The payment is also offered by them after they execute this illegal sale deed to people who have nothing to do with the company. One,
Come to page 94 of R4's counter.
yes.
This is your letterhead signed by you.
And yes, your lordship, yes.
And how did you do this? This document itself is a fraud.
Yes, the document.
This letter that you communicated is a fraud.
Has my wrong spelling also, I've indicated it.
So you're disowning this letter also.
I'm saying, your lordship, what happens is if your lordship will
Ashima.
your lordship will see the spelling ASHI.
Well, if you got your letterhead printed this way, you're saying that they printed your
Your
letterhead.
lordship will just permit me 2 minutes now. Your lordship will just permit me just 2 minutes.
This is a
Yes.
pot and the kettle.
No, your
Both
lordship. 1994, the allotment is made in my favor, in Ashima's favor, not in dispute. Till 2013, because of difficulties in this development, nothing happened. 2013, they tried to revive the project after 20 odd years. And they issue a demand notice to Ashima, as my learned senior pointed out, to say that please, now we are handing over the flats, please come and make make the payment. In those 19 years, as sometimes happens, the registered office of the company changed, the company stopped working, and it also got struck off eventually. So we did not get that demand notice. We were not aware of anything. We learn of all and what is happening is there is a syndicate that's operating because of these 19 years. There are some allottees who have, of course, not been vigilant about what has happened and lost track of the unit that was allotted to them in the mid-90s. A syndicate comes. A syndicate executes a sale deed in its favor from Ashima. Company has been struck off as the least of our troubles. It is executed on behalf of Ashima by one Miss Jaina Patil, who we do not know, not a shareholder, not a director. 1 crore is claimed to have exchanged hands. And I'll indicate my friend has in my SLP filed a counter affidavit. The SLP petitioner in the main SLP, Mr. Heath, who's the purchaser, has filed a counter giving a table of how that 1 crore is paid. In that table, not a single money goes to the company or its directors. In fact, money goes after the sale deed. There are 8 or 10 payments he says I made after the sale deed was executed in my favor.
Deepak,
So, Your Lordship, there are
next item,
two. If
10.1.
Your Lordship will have, there are two broadly aspects, if I may. Yes. If I may say, two issues. One is the issue is the whether the cancellation is right or not. If your lordship
The
finds,
very fact that you did not even file this SLP,
yes,
despite being represented before the High Court,
your lordship,
Till-
yes, I will, your lordship,
a year later,
your lordship,
over a year later.
I had indicated when my SLP was listed,
But he has filed application.
just if
before the
I could
company.
just permit me. I had indicated this when my SLP was listed and your lordships were pleased to condone delay when issuing notice, and this was the reason.
We normally condone delay. There's no.
No, but anyway, let me then not speak of the order, but let me indicate the circumstances why there was a delay. My case is that I have woken up after my allotment in 1994, only when the society files a complaint in the police station saying that we feel someone is trying to impersonate.
If you woke up at that point of time, why was there delay here then? 1 year delay.
Yes.
You're taking a short cat nap.
No, Your Lordship, what happens is that we do not learn of the impugned order passed by the High Court.
You're represented by counsel there.
No, Your Lordship,
Your respond number 3 before the High Court, Mr. Bhaskar Dwivedi appeared for you.
the counsel
In
that
94, how much did you pay for this?
Your Lordship, we
for
only
getting allotment?
Against.
Your Lordship,
94, how much did you pay?
yes.
How much did you pay?
Your Lordship, we only paid an upfront amount in 1994 about a
You
couple
got an
of
allotment. Then as you rightly said,
Yes.
you slept over it for so long. After that, what is the
No,
point?
Your Lordship will appreciate the reason. After I pay, admittedly, as per the special officer, also nothing happens till 2013. In 2013, efforts are bona fide made to try and now give the possession to allottees and demand notices are sent out. Unfortunately, since in that 19 years, some of these allottees have, of course, this being a company, things have changed
The
in
only
those
suggestion we can make to you is go back to sleep.
No, Your Lordship, may I
Step
indicate?
long enough,
Your Lordship, there's a very
brief intervals of consciousness.
Now, Your Lordship, may I just indicate what has happened? Why? I learn of this only when a complaint
And
is
your sale deed
Your
executed
Lordship will just permit
by a
me 3
company
points.
which doesn't even exist.
Your Lordship will permit me 3 points before Your Lordship will close, cancel.
Three documents,
Just,
Lord.
if
After
I could-
2018,
if I could just.
there is judgment, there is order of Calcutta
3
High Court
points.
in 2020. Then the special officer sends a notice that this much amount has been received from Asima Electronics.
Counsel, how do you get over the fact that you're claiming under a document executed by a non-existent
Even
entity?
if I assume, Lord,
There's no assuming, that is the fact.
High Court in 20, Calcutta High Court has
That
said
is
that
a
to pay
fact.
this amount. Calcutta High Court has said.
You have no title.
127 place.
You have no title. The company wasn't existing.
The company has revived, my Lord. Assets are there, my Lord.
So,
Doesn't
so
revalidate
even
the
all the High Court had directed your payment.
Yes, my Lord.
It is on the basis of the sale deed executed. It is an order obtained on a fraud. So then there is no question of that being compliance will not help you.
After this sale deed, Asima Electronics filed application before the Calcutta High Court. Money has gone more than
Sue him.
1 crore, my Lord.
Sue him. He's taken you for a ride there.
Person who
See, if 1 crore you claim from him, you please file a suit against him. Now that is also time barred.
his state.
Now they will probably give you the money.
Lord, one document takes
Which way you?
You want to take the money, please go to the.
High Court has
They
said
paid you
entire-
any money?
entire-
Society is kept it in a separate account.
Oh, I see, you kept it in the.
It's kept in a
Yes.
separate
Your
account.
art-
Offer to return it to the.
Your art-
Yes, Your Lordship.
So that amount will get back.
The end result would be, this asset would be available for me to be sold in an
That,
auction.
that amount was
This
paid
was to the
pursuant to which
depositor.
order?
Your Lordship, that after the allotment was cancelled, they,
Lord, the
basis of their sale deed came and said that we are depositing
No,
on behalf of
this
us.
order was pursuant to some court order.
They just.
You just accepted this.
Yes, actually, in fact, I said-
You're willing to return it, so.
Yes.
My Lord, may kindly
Very
see the
well.
order of-
So far as your case is
Calcutta High
over,
Court.
now anything more to offer? you-
Yeah, let me just make 3 points, Your Lordship. There are 2 issues before Your Lordship. One is, of course, the main issue of whether the cancellation is correct or not. The other issue is
The very
assuming.
fact that you did not even
I
respond.
will
all
explain
to-
that, Your Lordship. I will explain that in 5 minutes. Just if Your Lordship will just permit me 5 minutes. One issue
You
is.
can't say that I
cancellation.
made an investment, I gave some money.
No,
I can sit pretty on the basis of that, I don't
Your
need to
Lordship
make
will
any
just
further
appreciate,
payments.
Your Lordship will appreciate. Second issue, if Your Lordship accepts that cancellation order is perhaps incorrectly passed, is who gets the benefit of the restoration? That is a fight between the 2 SLP petitioners. Let me address Your Lordship on the
You're
first issue.
jumping ahead.
Yes,
You're
no,
not even come.
Yeah,
That's-
Your Lordship will just permit me on the first
To
issue.
begin with,
Your
you
Lordship
have
will
to
just-
cross the hurdle of your locus.
Yeah, Your Lordship will just permit 19 years passed by from 94 till 2013. The demand notices are addressed to an office which I show had been closed down in 2004.
You have to keep them updated about your changed addresses.
Your
There-
Lordship-
It's not their duty
Your Lordship,
to
90.
chase after
Your
you.
Lordship, after the company sinks, there is no one I can get in touch with.
Which company sings?
Once Ashima sinks, once Ashima.
Prima sank later, 2017.
No, Your Lordship.
This
And
society
Ashima
was
sank
formed in
because of-
2011.
Sorry, Sanchayani. Once
See,
Sanchayani
please,
sinks.
counsel,
Yes.
SEMA sank because of what? Your own default.
Yes.
In any event, even if we give you the benefit of that sinking, that's in 2017.
No, I'm saying
There
Sanchayani.
is a question.
Your Lordship put it to me that when your registered office
This
closed. you-
society R2 was formed in 2011. It
Yes.
is supposed to receive all the dues.
Your Lordship.
Did you get in touch with R2 and update it with
My registered
address?
office closes in 2000. At that point of time, neither Sanchayani was there because Sanchayani has sunk. I meant Sanchayani, not Ashima. And second, there are no officers who I can.
You need to go follow up and
Then
you
your
can't just say that I
Your Lordship will just
did nothing
just
in
just
2000.
consider the.
Thereafter, I need not do
Your
anything.
Lordship will just consider the equities here. Just last, Your Lordship just
Absolutely, all
just
equities
last
in their
submission
favor.
on equities. Your Lordship will take it.
Someone who just doesn't care about
Your Lordship will
his
just
dues
consider
or
the
following
equities for
up
2 minutes. Just last two arguments on equities. I won't take more than 2 minutes. Your Lordship, today, the dues are 33 lakhs. I've said I'm willing to pay them. That's point number one. Point number one. Point number two. Today, Your Lordship will see, assuming Your Lordship sustains the cancellation order, Your Lordship is depriving an allotee of 1994 and for whose benefit?
You're
It
still not
reverts-
telling us how
it
much
reverts-
did you pay?
Your Lordship, today I'm willing to make the entire
How much did
payment.
you pay? 1,000 rupees?
No, I made a
1,500?
1 lakh.
1 lakh.
Yes,
But
in 1994.
My learned friend should have been fair. He approached the company court with an application for permission to make the
That
deposit.
wasn't me.
When in 2020, and
That
there was an
wasn't-
order
that was
permitting
them.
him to make the deposit within 3 months. He did not even do that.
That also.
That also.
Your Lordship, that was them.
That was done, my lord. My lord, that was done by me, lord.
Your Lordship,
My lord,
today
that
we are
is-
willing to
When did
pay.
you make the deposit?
My lord, that deposit, your lordship, it is admitted case.
When?
In 2018, my lord.
2018, they issued
2018
some
is correct.
post-dated checks on behalf of some individuals claiming under the banner of Ashima. But since Ashima wasn't there, it was struck off. We kept it in a separate account. We approached.
My lord, my kindly see-
Your Lordship, today it reverts to the,
Having
Your
heard
Lordship
current
is
counsel
depriving an allotee of 94, it reverts to the special officer for whose benefit.
With the June judgment
Tenure.
passed by the High Court on 22/11/2020. The special petitions are accordingly dismissed.
Your
In
Lordship,
order of this
cancellation
court
will
dated
not inure
31/2020.
benefit.
My lord,
That's the only.
Stand vacated.
As far as
Pending
our fight, the
applications.
special officer can look into.
How do you propose to go about it? You'll be auctioning the flat.
Property will be auctioned, yes.
You participate in the
My
auction.
lord, my money, my lord, my money.
Your money, they're willing to give it back
My
to you.
lord, the order of the High Court is that it will be forfeited, my lord. My money will be forfeited, your lordship. My kindly direct.
Actually, we had
We will go
approached
to
the
the
High Court initially with this
We will go to the
application
company court.
to authorize the special officer to inquire as to which is the legal entity with the original allotee.
No,
On
whom
that
did you receive
application-
the payment from?
We received payment from individuals also.
Oh,
Two
not
persons,
from this.
no, no, my lord,
Lucian,
Lord, it was
your
by
lordship,
the Anil
it's the
Deshmukh.
checks.
My lord, my
Part of
page
our
136,
counter.
my lord. Page 136 of counter of our.
This Rajkumar Mohan Ahir,
He's deposited the amount before this honorable court as pursuant to the first order.
oh, see, there's amounts
Sir,
deposited with this court.
Entire amount was deposited by me, my lord. I have given 1 crore to
And
the
you will just see the checks.
We deposited, returned.
But this,
The other one,
Which order is that?
31st January 2023 in the main SL.
my lord, the interest part, court has directed that whether you are willing the interest part, I also deposited before the court. 1 crore I have given to them, my lord. That money is lying with the society.
That you'll have to
You're
approach.
getting it
the
back.
company.
Yes,
Getting
your
it
lordship,
back.
you gave me liberty to go to the company court.
Yes, that.
For the other amount.
For the
Other-
amount, they are.
For the other amount.
Which order required you to deposit with this court?
That was the notice issuance notice.
31st January
Very
2023. 30th January.
The amount deposited by Rajkumar Mohan Ahir, learned counsel, the petitioner in SLPC number 1781 of 2023, lying with the registry shall be refunded to the said petitioner under proper acknowledgement along with interest accrued thereon. In short-term deposit,
Let one more thing. My lord,
along with the interest accrued thereon.
the consideration of the entire
Further, any other amounts deposited by the petitioner so and so with the respondent society, which have been kept in a escrow account, may, don't see any other amount. We give liberty to the petitioner, Rajkumar Mohan Ahir, and to approach the company court for refund of any other amounts paid by him to respond number 2 society, mention the name also,
With proof.
for refund thereof on the basis of file an application, I think, with supporting documents.
Next, Milord, one more thing. Milord, that property, they have the Asima Electronic, the property in the name of Asima Electronics. It was under consideration by the High Court till 2020. For the right, because what High Court has said that the Asima Electronics was not able to show the documents with regard to payment after 2020, therefore it is cancelled. That right with regard to the flat that.
Why are you arguing for him?
Even if, because Milord,
He doesn't want to be
one line, Milord, their statement before the police, they have admitted everything that they have given to me, Milord.
Nothing.
Even if it goes to.
The sale deed doesn't stand, nothing more.
Milord, the sale deed was brought.
Once the sale deed goes, your title document goes.
The sale deed was brought to the notice of Calcutta High Court. Calcutta High Court said that.
How do you validate it, counsel?
That's why we are
It's
telling
executed by a non-existent entity.
it's an order procured on fraud.
Milord, the asset of the company remains, Milord.
Nothing more comes. Participate in the auction, maybe you will be the highest bidder.
And great.
Please, my lord.
Yes.
There is an IA for impediment by the bank in the matter, my lord. There was a direction passed by Honorable High Court at at page 16, my lord. Before my lord start hearing the main matter, may I draw my lord's attention to page 16, where there is a direction to recover the stamp duty from the lessee bank, my lord. To that extent, my lord, I may be heard in the matter, my lord. That's my
Is
request. to this
stamp duty
honorable.
payable? Where does it say it has to be recovered from the bank?
My lord, if my lords will have last 4 lines, my lord. Last 3 lines, it is open for the plaintiff at number 1 and 2 to recover the stamp duty from lessee in accordance with law. My lord, I am the lessee, my lord. Page 16, my lord. Yes, my lord. 1-6, my lord. Impugn order, my lord.
Yes. Where is this portion that you read out?
The last,
Lord,
very last lines, my lord,
In view of the.
It is
no, just before that. It is
last 3
open-
lines, my lord.
It is open for plaintiffs
Yes.
one to
No,
Right, my lord. Right,
recover
my
the
lord.
stamp duty from the lessee in accordance with
the deficient stamp duty
Yes,
is on
my
the
lord.
lease deed.
Yes,
the lease deed.
on the lease deed.
Then necessarily it has to be recovered from the lessee.
Normally lease deed 50-50.
Not necessarily.
Under the Stamp Act, the provision is lease deed, normally it would be 50-50.
My lord, basically, my lord, there is something more which I wish to bring to my lord's notice during the pendency of this matter before this honorable court, my lord.
He's entitled to be heard.
On
He's
Yes.
entitled to be heard.
Yes, my lord, very well. Very well.
And
He has not
We have no
challenged.
objection.
He has not challenged it.
IA number 30464 of 2026. This impediment application is allowed, and the Indian Overseas Bank, the applicant, Bengaluru, the applicant is brought on record as respond number.
It will be respondent because 7 minutes because.
7.
my lord.
Respond number 7. Liberty is granted to respond number 7 to file, duly implemented respond number 7 to file its counter affidavit by the next date of hearing. Deletion application.
Please, my lord.
My lord, I'll just check that.
Please, my lord.
Respondents were
Please,
deleted.
my lord.
Give the respondent number, correct respondent number I'll give. My lord, certain respondents were deleted.
Certain respondents were deleted. Already deleted.
Yes. Just give the correct
There
respondent.
must be an order.
Yes.
Suit is still pending.
Yes, my lord, suits are still
3,
go on.
4 and 6
Can
are
go on. In the plaintiff, the suit
So
has to
one
go on. To that extent, I filed an application.
5 will be respond number 4 there. 3, 4 and 6 have been deleted.
Yes.
Yes.
Yes, my lord.
3, 4 and 6 is order. It says 3, 4 and 5 are one. Anyhow, so
2008 suit is still
2008. I think there's an order here.
17.
Stay of suit is there.
My lord, I have filed an application. If my lord would take up that application 134702,
We finished the.
Because one more suggestion was, this is a family dispute. If my learned friend is agreeable, can this be referred to also mediation?
After saying.
This is mother and the sons fighting. I'm the
Mother and
mother.
son fighting.
Yes.
Well, my friend did call me. I have taken instructions. Before the trial court, the same submission was made, referring the matter to mediation. The matter went for mediation, but unfortunately, they never appeared. It was pending there for 1 year. Then, and one fine day, they came back and said that we are not interested in doing any mediation. That is
They
all.
said that.
They said
She's having second thoughts.
she's having
She's
second.
your mom. She's your mother.
Well, my brother is controlling her. Well, that's the case.
Still a brother.
Still a brother. But
Maybe you can sit across the
well,
table. and-
emotions of the brothers are the same. Well, whether it's Ambani's or.
This is just a property dispute. I am at.
Are you willing or are you not willing?
Well, my instructions are that they never came for the mediation, and it is the brother who is driving this litigation, and therefore he will not allow a settlement. This is only to delay the proceedings. I have filed an application for vacating of this interim order. At least the trial should go on. They are only
This is your partition.
my suit, my lord. The trial should go on.
There were five
It's been
suits.
pending
Sovereign rates.
Five suits have been clubbed together.
All that there is no dispute. I mean, the stamp duty can be recovered from whoever it has to be recovered.
The only issue is that
mediation or not.
the court did not impound the document. That's the only issue, is it?
Yes, the
That's
penalty.
the only issue.
Trial can go on.
No penalty has been imposed under the act.
Once
Penalty is
Yes.
The
discretion.
impounding, everything is done by the authority concerned, not the
Authority,
court.
Here the court is also, that's for the bank to the bank.
But the High Court says no penalty to be imposed.
That the High Court can say. The authority.
Therefore, those two judgments, it
You
also.
want penalty to be imposed.
That's right.
You are on a totally different thing. You are not concerned with the partition at all. You are fighting for the state.
Yes, no,
You are fighting for the state.
No.
That's it.
Well,
You want the penalty to be.
They are indulging in the small skirmishes so that the main battle doesn't take place.
No, absolutely. I am ready with the main matter. Your Lordship may hear it anytime.
The state is not interested.
Open for the plaintiffs to recover stamp duty.
I don't know what is. Impound the thing, and the authority will take a decision.
Let it be impounded.
This exercise ought not to have been undertaken by the learned judge himself.
So,
Well, the documents are exhibited today.
However, they are
They never
exempt from
objected.
payment of any
Leave
penalty.
all that. The stamp duty is deficient. It's for the stamp authority to.
They will
find
come
out.
and take over. The suits can go on.
So once the court is apprised of a document which might be deficitly stamped,
Well, I have,
the duty cast on the court is to impound the
well,
document.
there are 3 documents which are in dispute.
you produce the document.
Yes, Minister.
I produce the document.
What is the deficient stamp duty?
Then they say the dissolution deed ought to have been compulsorily registered.
That is being rejected.
That's been rejected on the ground.
To lease the.
Let my friend.
Only the lease deed. Only the lease deed is shown.
Only the lease deed. That is for the bank. That so far as the dissolution deed is concerned, the body of
That's
case was very
that's
clear.
rejected. They've not.
They have not challenged it. So it's only for the lease deed. Lease deed is
Only
between
the
the bank
lease
and the
deed.
bank.
Only the, yes.
So the suit should go on.
Yes.
Stamp Act.
But this will be the Karnataka.
Provides in
Yes,
Karnataka.
the local act will apply.
There's a separate one
Yes, section 34, Minister.
with regard to impounding.
Yes, Minister. On deficiency, Minister. Kindly see section 34.
Examination and impounding of instruments 33.
Yes, Minister.
Yeah,
This is chapter 4, Minister. Section 33 creates a bar. May I place from 33 onward? 33, 34. 33 minutes. Every person having by law or consent of parties authority to receive evidence, and every person in charge of a public office except an office of so and so, before whom and in any instrument chargeable in his opinion.
So this is the power that the learned judge ought to have exercised.
Yes, impound the same is what it provides. And then Miller's 34, it says, Miller, no instrument chargeable with duty shall be admitted in evidence for any purpose unless such instrument is duly stamped. Provided that
The trial court rejected both objections.
yes, Miller.
So they
Yes,
never
my lord.
at the time of marking, at the time of exhibition, there was no objection raised.
Very well. If at all any necessity is made out, it's under 33(1).
33(1),
Yes.
that is for the lease deeds. The dissolution deed, there is no,
Resolution deed, there's nothing.
there's nothing. So
For
the,
the lease deeds, Miller.
so this
Only
petition
But they
can
also
dispose
have-
of.
they
The
have-
bank can go and raise its issue there.
Where is the penalty?
Yes, Miller. In 34 minutes, provided that, would my lord see?
Yes.
Provided that any such instrument not being an instrument chargeable with with a duty under so and so or a mortgage chargeable under clauses A, B of section 3 with a duty shall, subject to just exceptions, be admitted in evidence on payment of the duty with which the same is chargeable, or in the case of an instrument insufficiently stamp or the amount required to make up such duty together with a penalty of 5 rupees, or when 10 times the amount of the property duty or deficient portion thereof exceeds 5 rupees of a sum equal to 10 times such duty or portion. So it will be 10 times of the duty or the portion to be charged. And this court has considered this very recently,
Okay.
When is this document admitted in evidence?
Yes, ma'am.
It was admitted in evidence on
somewhere in December 23, when the application was filed.
12/23.
2/12/23, 8/12/23 application.
This is after the stamp duty is paid.
No, after, no.
So the so it's not for the court, it's for the authority concerned to exercise.
That's right. Well, the High Court now
Only thing
says
is
that
35 with
Yes.
regard to when you can raise an objection. Are you not, you're not covered by 35?
Look, I am covered by 35.
Yours,
Javed Chand's
covered.
judgment
The
of-
trial court says it's covered by 35?
No, the Javed Chand's,
No, when the trial court rejected it, these objections,
well, the trial
did
court,
they apply 35?
no, Mullah,
23 to 24
what happened
order?
was, what happened in the trial court was,
no discussion in the.
let my friend finish, my lord, I will place the order sheets.
No, let's just have some clarity. Where is the 23 to 24 order?
If my lord would take IA number 228196 of 2025.
Which is at page 92.
Of the main paper book?
Yes.
92.
92. The one-page order.
But I am showing the deposition itself.
These two applications are filed by the defendants to so and so, praying to reject the irrelevant and inadmissible evidence documents produced in evidence tendered by the plaintiff number so and so, as it is not
See,
duly
that is
stamped
why-
as per the
That
Karnataka.
is why he says that. When was it tendered in evidence? That
But
is
if
the
I can
time
place the facts,
at the 35.
my lord, if I can place the facts,
Yes.
when I tendered these documents, it was not admitted in evidence. I have not stepped into the box. At that point of time, they filed these two applications. The court said, we will see as and when the application, as and when you step in, whether you choose to mark it or not, we will see it at that point of time. When it was marked, they never objected. They objected to the other documents.
But then the
I'm just placing the facts. I'm just placing the facts. They never objected. Subsequently, they filed an application saying that this is sufficiently
Much later.
much later, my lord. I just give the date.
When was it admitted in evidence?
It was admitted in evidence on 2/12/23.
2/12/23.
It is at page. I have filed an application to have additional documents.
And I filed the application on 8/12. Within
12.
8/12. And the order is below 23 to 24.
If my lord would take that application, 228196. Application number 228196. My lord would come to page 9.
Yes.
This is what happened on that day. Page 8 onwards, the proceeding starts. Sorry, page 9 onwards, 2/12/23. My lord has it.
Yes.
It's handwritten on the left side. On the right side, defendant aid counsel present. Plaintiff counsel files an application for extension of the heard the application, allowed temporary injunction is extended. PW1 present, plaintiff counsel files further examination in chief, PW1 got marked exhibits P3 to P96. Praised time for further evidence, hence time granted. So this was done. Then my lord turns over.
Just see my objection there itself. Defendant counsel praised time for objection. Hence time granted.
Yes, my lord. Then my lord at page on 812, my lord sees the turns over. Plaintiff counsel on so and so files an application for extension of time, so and so is granted. Defendant hence the application is allowed. Temporary injunction is extended till the next date of hearing. Defendant 1 to 3 file objections to application number under order 7.
So he filed it almost immediately.
Yes.
Then I have this to say. If my lord would take this Zaverson's case, where the court says when you are challenging the document on the ground that it is insufficiently stamped, you should do it then and there. It can't be postponed for another.
He did say that objection.
No, my lord, that objection is raised time for objection to order 7 rule 14 application, not that application.
Your which page was that? The first
Page
one?
9.
Already he had filed an application when you tendered it.
No, when it was filed.
When it
Earlier.
was filed, he had objected to it.
So today, it is for the bank to pay. So, my lord, all I am saying is,
Just set aside this portion and say that the document will be.
and the trial will proceed independent of this.
You don't want the document to be relied
First,
upon.
it has to be relied on.
That's right.
No, my lord,
The document will have to come back from the authority.
my lord, that is only these documents will go, not the entire case file.
You want to give up the document?
I don't want to give up the document, my lord. In so far as the
How can the trial proceed if you want to rely on these documents?
my lord, I am relying, but in trial in so far as the other aspects of the case can proceed.
No,
others
but
will
the
proceed.
witnesses will need to be asked about this document.
My lord, this is only a lease deed, my lord.
Even that,
You tell us that it is not required, we'll only direct the impounding definitely has to be. Because whether
I'm
you
saying
rely on it
whether
or
you
not.
rely on it or not, it will have to be.
Then would my lord would take up the violation which I have given.
We'll have to stay this until the authority concerned takes the
Well,
necessary
This
action.
is only delay tactic, my lord. They never.
Then you decide, you don't want the lease deeds, then we can institute them.
You could have said this long back. Now, either if you don't want to rely on those documents, the impounding proceedings will be independent of that suit. But if you want to rely on that, then you will have to wait for this. What do you
My
call
lord, I am saying something else, my lord. If my lord would appreciate, the suits are about a decade and a half old.
Understood.
That is where
That
we are.
doesn't still make a difference. If you wish to rely on these documents, you will have to
I am saying
wait.
something else, my lord. I am saying, in so far as this aspect of the case of impounding of these documents is concerned, my lord may indicate a time-bound date and from whom it is to be
Don't
recovered.
fix timeframes even for
So, my
authority.
lord, this will take another.
Provision itself has some
No, it doesn't fix any time. It doesn't fix time.
timeframes.
Because I have practiced in that part of the world, my lord. It takes
This act doesn't have any.
this that. So it
Normally
takes.
under the Stamp Act, I think some timeframes are there.
Yes. There are two judgments.
Very well, we'll fix the timeframe also.
That is number one. Number two, in so far as the other aspects of the case is concerned, the trial should proceed. There are three others.
There's no question.
You either say that you don't want to rely on it, then fine.
No, my lord, I have to say because
Then all witnesses will have to be recalled and what?
there'll be no other witness, my lord. My evidence can go on.
But then what about these two documents?
But these two documents are only the lease deed.
So none of the other witnesses will speak about it.
Not only the authors of the lease deeds will speak about it. The bank and the
You have
executor.
to speak about it, then if you have to
The
speak
bank
about
and the executor will have to speak about it.
The man who executed it is you.
No, my lord, my brother.
Then,
They were the power of attorney.
then probably only after the impounding it can be done. How can they speak on the lease deed which is not absolutely in evidence?
Well, in so far as the other, they have challenged the
They
case.
will have to continue.
But
We'll only fix the timeframe.
You want me to write it?
Granted.
We'll say 1 month or 3 months.
3 months. For the authority to. Let the impounding take place. We will set aside that portion of the order. So the bank need not be considered.
Well, I have from the compilation where it says that it should be objected as and when it is tendered.
It is objected, counsel. Mrs. Srinivasan, don't.
My lord, I am only demonstrating from record what it is.
Don't.
Whatever
what
it
is
is,
that
even if
expression?
it is
Don't
not,
spread the
it
small
has to
stuff
be
now.
impounded. No doubt it has to be impounded.
Lords, just for my understanding, Lords, on the penalty part, High Court has
That
granted.
is for the authority concerned.
Yes, Lords, but
We are not going to say anything at all.
no, but Lords, there are judgments which.
Who is
You
authored?
produce the authority, the
Who has
judgment
authored
before
this
that
lease deed?
authority.
You did it.
The
Who authored?
father and the brother also.
Father and the.
My father and my brother.
So then
But
they
I was
will
not
have
here.
to, they'll have to pay the penalty, not them. Who produced?
Because he produced those documents.
He produced it. He is not the author. What are you saying?
Stamp duty will be paid by the
Come back to
executive.
bite them. I'm going to come back to bite them.
Under the Stamp Act, as far as I remember, where it is a lease deed, stamp duty is normally paid by both 50-50.
I'm sorry.
Unlike a sale deed.
In that part of the world, my lord, we have taken houses on rents. In that part of the world, it
Mother-
I
is
don't know whether this act has any
Party
such.
to that.
it is only the tenant.
Mr. Balaji.
Only the tenant pays, is it?
The tenant pays. Even in Delhi and in that part of the world.
I think the tenant pays it always.
It's the tenant who pays.
Is there any provision in the Stamp
Where is
Act?
the Stamp Act?
So it is a this is the
In
bank.
the Stamp Act, I
Tenant-
remember there's a clause which says lease deed, it will be 50-50 usually. Somewhere, but anyhow, we are just wasting time. For another case, you can. There is something somewhere, look it up and.
Because under 34 Lords, whoever tenders that document
I'll
and Lords,
return the document on
please,
within 2
Lords,
days.
this is from the library itself.
Your library.
No, Lords, this is the Supreme Court library.
Supreme Court Bar Association Library.
Yes, yes.
That's what.
If my lord is paid
Bar
61,
Association Library is by the Supreme Court itself. I don't know. I'm
So
asking.
there is a separate judges library, your Lordship. So there we've
there's a
also
separate
given a
judges
print-
library, there's an association library.
Oh, this
In
is
the
a-
association library, we can take the books.
Okay.
The old practice was the books will be left here and will go back to the court on its own.
So they've provided one printout copy as well, Lords. If your Lordship
After
want to
2
wish
days,
to
please
retain-
ask the courtmaster. Somebody will come with them.
No, the print copy is given, Lords. If your Lordships want to keep that print copy, Lords, of the act.
I'll wait for this.
There's something on these, but I remember there's something somewhere.
Plus 34 says, Lords, the instrument which has been relied upon or tendered by the person, Lords, he will have to pay the penalty, Lords. Therefore, it will eventually come upon him, Lords.
If my lord
He is the person who is relying on it.
That's right.
My lord, ultimately the authority will decide, my lord.
My lord, just to put the records clear, in the application which I was showing, page 61 and page 67 are these two lease deeds. First lease deed is signed by my late father,
61 and
61 and 67
in the main SLP.
in the IA,
228196.
where I had read the orders.
Yes.
In that IA, it is executed by my late father.
So pious obligation.
I'm sorry,
Pious obligation.
pious obligation. And my lord, my brother, brotherly love.
Yes.
So these are the two lease deeds. One is by the Indian Overseas Bank.
Second one is executed by
You're right.
Bhagwan Das Sharma.
I don't remember.
Bank, you will have to pay the amount because the list.
I'm mistaken because the Stamp Act also says it's to be paid by the list.
Everybody-
So I remember reading somewhere that
Then
the
Mr. Joshi will say whenever he buys properties, he pays the stamp duty.
where I saw it.
No, there,
Let's
those
go ahead.
judgments, because we had relied at the notice stage also, your Lordships have referred to that.
But
On the interpretation of this section particularly, this is the Gangapa's judgment. This judgment is, may I just give out the citation, 2019.
you have the copy.
Yes,
Yes, we have it.
this is 2019 3 SCC 788.
What does it say?
They have interpreted section 34 to say that the penalty amount is mandatory and that has to be paid.
That's okay. Then
Yes, and there's a 2024 judgment also.
Judgment makes it mandatory.
Well, ultimately, it will be the authority which will decide.
That's all.
Judgments are required.
Get this book after 2 days.
Please.
Otherwise, it will go to his account. My lord. He will
Happily,
come with a subscription dues.
I don't want to pay the stamp duty, I'll pay for this.
So should I pass on these judgments as well, my lord? Ravesh Chand.
regard to raising an objection.
With regard to as and when the objection has to be raised.
And so obliged. Wait.
Order.
Obliged, my lord.
Order is there.
The entire paper.
Looking at that.
Order is there.
Obliged.
Well,
Okay, please, Lord.
Appear for respondent.
Here is a seminal question is that whether High Court is justified to refer the direct to trial court to refer the tenancy issue to the competent authority to be decided in a suit for redemption of mortgage. That's the issue here. I already handed over one written submission, note of written submission, if Lord, I'm going to have that. Yes, lots of. Now, so, may I just give list of dates, or shall I directly show it from the paper book?
is it there in this? List of dates is,
I gave it. Yes, Lord.
the written submissions begin with the list of dates.
Yes,
Yes.
I had given
You have it?
that. Lordship here,
Yes.
may I just give a factual background orally first to the judge?
Yes.
Here are 3 suit properties. There are 2 suits. One suit property is 196/2 and 211, for which there is one suit, and another suit property is 198, for which there is another 2 separate suits.
96 and 211.
211, one suit of
One-
2015,
And 198.
198 separate suit of 2011. Out of these 3 properties, only prior to gut number 198, there was an entry of their tenancy in 1954. Entry was made. Under Maharashtra Agricultural Tenancy Act, proceedings were held under section 32G. Competent authority found that they are not in possession. Therefore, in 1961, their tenancy name was directed to be removed and that order was passed. Accordingly, from 1961, our names were entered as the owner and possessor of the property. Thereafter, the 2 mortgage deeds were executed. One is in 1981 and one is 1979, by which we gave them a mortgage of this same property.
Very same.
Same person.
All 3 properties.
No, very same
the-
respondent who had.
Yes. That is, in 1971, first document was executed.
79.
79, sorry. 1979, first document was executed, and 1981, second document was executed. That document categorically says that possession is given today. Categorically says that possession is given today. That document won't say that they are in possession as a tenant in the property. That documents are on record. Then I filed a suit in 2011 for redemption of mortgage. First suit filed in 2011, second suit filed in 2015. In first suit, issues are claimed in 2012, and that suit proceeded for final argument in 2020. When that suit was fixed for final argument, they filed an application saying that there is an issue of tenancy arises in this case after 60 years from 61 to 2020. There is issue of tenancy arises in this case. Frame the issue and refer the matter to the tenancy competent authority of tenancy court. Learned trial court said this is completely delay tactic, and from 60 to 2020 nothing has been done. Their names were removed and rejected that application. Similarly, same application is filed in another suit in 2020 after 5 years when issues were framed.
In your redemption suit, what was their defense?
What they took a defense of they are holding possession of the land even before the mortgage deed. That's their defense. But whether this issue should be referred is the question here.
Did they admit the mortgage deed?
They admit the mortgage deed. They admit mortgage deed. It is
But
undisputed.
claim that they were in possession even prior there.
Prior to that, that's what the oral claim only.
No written submission.
Yes, but there is no document to suggest. from 61 till the mortgage, they were put in possession in 19.
On what basis? In the written submission, what do they say? Because we were in possession prior to the mortgage,
As
therefore,
a tenant.
As a tenant.
Did they say
the
that?
written statement.
Yes.
Yes.
Then
What
that to
their
Nineteen
case is that.
37, my lord.
see, then that issue is already raised in defense at the time of filing the written statement.
Yes, yes. So here question is.
So then court should have done it by itself.
In fact, there is a prayer also in written statement.
Just.
Then how can you
No, just.
say that it is delaying that?
Their 19.
if they had not said that in their written statement and they come up with an application later, then you may have a point.
They
But
said.
if in the written statement itself, they've taken the plea that we are tenants, we are not claiming under this mortgage, therefore we are not
Right.
liable to be divested.
Just asking.
Where is the written statement?
Yes.
My lord, correct translation, I have filed it. There are errors in this translation, my lord.
Where is it?
That is
I have filed
there.
additional documents, my lord.
Just.
Page 8, IA for additional documents.
But even I have filed it, if Lordship will see
I
SLP,
1770.
Yes, my lord, the recent. Yeah.
112 of SLP.
No, you don't mind.
No,
yeah.
You think that that is also correct.
Which page is your?
Page 8, it starts, my lord, it's filed in 2011.
Yeah. 2000.
And from 10 onwards, there are pleadings for the tenancy. Paragraph 8. But may I read it?
Illegally deleted in, yes.
And since 37, my claim is there, my lord. There are entries to show that.
Para 8 is it?
Yes, my lord. May I read it?
Not necessary.
No. Go to the case.
And my lord, end of the para 15, there is a prayer also.
Tenancy has been duly referred to. 6162 name was deleted from the record. Suppose
What is the
name
new?
was referred in 6162.
What is it? Stated
They've
that-
said paragraph. This is void. Neither
See,
the defendant
1961
nor
it was
their
deleted.
predecessors.
Yes, there are no records of that proceedings at all.
Please.
Yes,
See,
yes.
you can, your own admission.
Yes.
You say that it was illegally deleted in the year 1961.
Yes, it is because.
Please,
Yes.
please, bear with us.
Yes.
Then you didn't take any steps. You are aware of it.
It is a public record, so you can't say that you are
And-
not aware of the fact that your name has been removed.
And
Especially when you enter
Under
into
the
these
mortgage
mortgage deeds where you're not described as a tenant.
see,
You accept that document, is it not?
No, my lord.
See,
So
Therefore,
you are
Lord,
just
you
trying
had
to
not
draw
a-
advantage of your past status.
Lord, before High Court also, same submission was made.
no, we are
But
asking.
High Court granted them time to produce the copy of that orders,
For
that proceedings.
Leave the order.
You are aware of.
Admitted fact that the mortgage deed doesn't describe you as a tenant.
No, my lord. Yes,
Admitted fact that
Yes.
your name ceased to be in the
Yes.
revenue record
Yes.
from
yes,
1961 onward.
yes.
Those are enough.
No, my lord, since 37, I am the tenant.
You're only taking advantage of the fact that for whatever reason, they gave the mortgage back to you
No,
again.
my lord, therefore.
That doesn't mean that you are
the order of the
entitled
High
to
Court, my lord.
just revive everything
I think we're going to the
61
High
to
Court order.
2011, you do nothing at all.
No, tenancy can't be extinguished, my lord. It's a benefit legislation and as per proceedings of.
We are asking.
Tiller's Day,
Yes, I'm in possession.
1457,
I'm in possession on Tiller's day itself.
which means that you have to do whatever you need
No,
to under that
no, my lord. It's a tribunal who has to issue notice.
whatever.
Lord, what has happened?
And in any event, now the reference is only to decide whether the tenancy is there.
That order is also complied with, my lord. That issue is framed. It is already
It
referred.
is framed in the suit.
Yes, my lord. It's
Whether
referred.
there is a.
It's referred.
Not referred.
Yes, my lord. After High Court's order,
Trial
it's framed.
court rejected. Trial court
Trial court
rejected their
rejected.
both
No,
applications.
in the issues, any issue framed with regard to the
No,
tenancy
no,
at all?
No.
When were the issues framed?
2012.
Oh.
And they made a.
And you took no steps after the framing of issues?
My lord, my prayer is there in the written statement.
Framing
That's
of
okay,
issues.
framing of issues. You are,
Lord,
Issues
that's an
are
order.
framed.
No, my lord. After that, I have only filed this application.
In these courts, draft issues are submitted by both parties to
Yes,
counsel.
yes, and
Did
there
you submit a draft issue that the tenancy issue should be
Lord,
framed?
I am not aware of this.
Yeah,
my lord.
Then
No,
where-
too late.
My lord,
all this is over.
Too late.
No, my lord, see 37. First, my lord, a few entries, my lord.
And
You
two
are
judgments
just
of
trying
this
to
court.
take advantage of,
No, Lordship may see then, my Lordship may consider my submission.
you almost had us also, but no more.
Lordship may see the entries itself, my Lord. Lord, then permit me to make the submissions, my Lord. Permit me to make submissions to that. Something. Lord, my learned friend is relying on the 61 proceeding. There is no record in existence, my Lord. That is
You admit it. That's the whole problem. You admitted it.
Written statement,
And
you
then
admitted it.
mortgage also, mortgage deed also. Why did you?
Lord, I say that, my Lord, as per the usual practice, although I was in possession of this land,
You've admitted it, that there is
What
a
I have-
cancellation in.
no, my Lord, what I have admitted is they were required of additional money, my Lord. Although I was in possession, mortgage deed was little, my Lord, and I paid the money.
Too little, too late. When the issues are framed, you do nothing. After that, 61 to 2011, no steps taken.
My Lord, for then, my Lord, Lordship may see the provision of
Granted.
tenancy act. My Lord, my tenancy
Will
can't
allow-
be extinguished.
Judgment to follow.
You yourself did it by your action. Yes.
Lordship may see the provisions, my Lord, the tenancy can't stand extinguished unless there is a recourse to section 14 and 15.
There's nothing more to be said. Okay. Timber watchers.
Please, Your Lord.
Yes.
But the issue involved in this case is person who were appointed in a non-pensionable establishment of the state, that is the corporation, Forest Corporation Lordship, which is under EPF and CCF. But once they are appointed into the government forest department, whether the services which were rendered in the Forest Corporation, which is non-pensionable establishment, can be counted after their appointment into the government service is the only issue involved in this case. And in the Forest Corporation, the service rendered by them, they are getting the Employees Provident Fund pension also. So now they are claiming for two pensions for service rendered by them in a corporation and in the government department. On brief, I may submit, Lordship. Initially, they were appointed a timber watcher, class 4 employees in the Forest Corporation of the state. Admittedly, my Lord, Forest Corporation of the state is a non-pensionable establishment. It's a all corporation but non-pensionable establishment.
Right.
But in 1999, a scheme was floated by the state government for the corporate sector, including different corporations of the state. But in 2004, my Lord, the scheme was withdrawn by the state government. I'll submit a chart to my Lord's Lordship.
What was this scheme?
This scheme was pension scheme for corporate sector of the state. Lordship.
But that was only from 99 to 2004.
2004, Lordship. So person who retired in between were given
Those
the
states. Only those who retired during those states.
during those periods were given.
None of them are covered.
Yes, sir. They are not there, Lordship. And this matter is settled by this honorable court in HRTC versus Rajesh Chandra Sood, that this scheme, the withdrawal of the scheme is upheld and said that only those persons who were retired during that period will be entitled for the benefit.
Right.
Now, Malad, there is this,
Citation.
pardon?
Citation.
Malad, it is 2000.
Might not change. Is it right?
2016, 10 SEC, 77.
2016, volume 10 SEC,
77.
page 77. Now, Malad, there is a provision in the recruitment and promotion rules for the appointment of forest guards that some persons from
It's at page 125 of your Lordship's SLP also.
Judgment is placed on record with the SLP.
That's okay. That's okay.
that's I'm giving the facts, Malad, first.
Very good.
Malad, then
What do your rules say with regard to recruitment from the corporation?
yes, sir. Earlier rule has. Malad,
Which
rule
page?
says,
Have you not filed the rules?
Malad, rule is not there.
We need to see the rule. How do you bring in people from the corporation into
No,
the
rules-
recruitment?
rules
Forest
are there.
department.
Rules are there, Lordship.
But we need to see the rules also.
Malad, page 45, Lordship.
The full set of rules are not there.
Malad,
Notify some letter.
Malad, may I permit, I may be, Malad, may given time, 2 weeks time, so that I may place on record the entire rules. For set of rules.
Rule without
Could
the
have
rules, how
just
will we
brought it
decide?
here.
Yes, sir.
So just brought it here.
What are these rules called? Are they?
Malad, they are
available
for
in
the
library?
recruitment of forest guards, Forest guard, recruitment and promotion rules. These were 1973 rules, probably.
Probably if you.
These are Himachal Pradesh.
Yes, Himachal Pradesh forest guard rules. So, Malan, it's a limited direct recruitment quota is prescribed for all corporation employees.
Just check in the computer.
If
Google.
it's there, it's
Google. Himachal Pradesh.
Himachal Pradesh. Just give us the correct title of the rules, please.
Himachal Pradesh for forest guard, recruitment and promotion rules. May I get it on the Google? In case my lords may short password, I'll get it, lordship. Within 10 minutes, I can get it. Lord.
You can get it?
Yes, sir.
We'll take it up after lunch.
Yes, sir. My lord, I'm deeply obliged, I'll get it.
Your lordship will permit me after lunch, my lord, I'll cut short the things. Reason being, what the High Court has said is, we are ready, I have advised my clients to give up the arrears and put a lid to it.
Arrears from which date?
Arrears for the services rendered in the corporation. And the services.
But you want that service to be counted for the pension that would be payable in the forest department, is it?
Counted and the pension to be worked out on notional.
So then you are getting the benefit of that service twice over.
Not twice over, I'm so sorry.
Because the corporation is paying you something.
Corporation is separately paying
Yes.
for the period. Government is paying for the separately for the.
But how do you
period.
count the same service twice?
Will you give up to the corporation pension now?
Exactly. Exactly.
They'll give
You
up.
will give up.
I'll give up.
Very minimal. Provident fund pension.
Provident fund.
Provident fund will be very minimal.
But now we are
Very
getting the
minuscule
pension
amount.
government also, Lord.
See, what they are suggesting is,
Yes, sir.
give me pension from next month. Whatever they have taken on the earlier this thing, arrears, they don't ask. And they will not ask for the corporation's pension hereafter.
Only
correct,
service.
It is not applicable to one service, my lord.
They have
Entire
counted by
corporation,
seniority.
2015 corporation, wherein then this problem will come.
Will come again.
But it is coming recurringly to the state
We need
government.
to have a decision.
Yes, 70 onwards,
Very well, then we'll.
till onwards.
Then
You can't
all right.
be a panchayat.
We'll hear you after lunch.
Please, sir.
Try to get.
There was a bidding also, open bidding, and the response number 2 is the highest bidder matter. So the only thing needs to be done is they need to pay the money to us. So this is a small issue. It may be kept on any miscellaneous day matters.
Is the council here?
Whereas he was there, I requested them. He was there in the VC in the morning. Malas he was also there, but
We asked you to make a mention in the morning so that we could
Malas
pick
is
it up in the
request.
afternoon.
The humble request is just.
Where is the council now? Council is not there. Very well, take it out at 2 PM. Which item? 98.
98 matters.
Get the council.
Yes,
Without the council being here, we can't.
My lord, item 14.
God bless.
Let my senior advocate K. Parmeshwar, sir. He's not available today. Requesting for an adjournment.
Wait till.
Hold up 2 weeks.
a matter at 120, where your lordship had heard not the arguments, and as per the last order, your lordship had given the respondents last opportunity to purge themselves of the contempt. Now, not this matter is at 120. I know your lordship's board is very heavy, but this is really being taken as a very long road by the respondents, not the implementation of my orders.
Did we not say the matter will retain its position the last date?
It did, my lord. On 10th, it didn't reach. Therefore, it's posted for today. My only submission is
No, when did we give this opportunity to purge
17th
them?
of February.
17th of February.
February, your
the
lordship
matter
had heard the arguments, and this was the order passed by your lordship.
But we didn't say that on the next date, the matter will retain its position.
No,
Why did
that your lordship did not say. That your lordship did
Oh,
not
we
say.
did not say that.
I think this is the one that came from the tribunal. For promotion.
Promotion matter.
When seniors were.
My lord, my lord.
You had half of the probation.
Exactly, Lord, exactly. So if your lordship could take it up any day and higher up on the board, Lord, I'll be.
120. 120.
My lord.
120. Matter may be listed at the top of the list next Tuesday.
Great.
Malas, may I mention item number 98?
You got the other side with
Malos, is there Mr. Sujoy Datta is on the other side, Malos. He
Where
is
is
there.
it?
VC Malos.
98. Yeah.
Yes, Malos.
What is it that you want now?
Malos, there is a open bidding, Malos. In the bidding, Malos, the local commissioner was appointed by this honorable court, Malos. In the open bidding, the
Conducting the inter-se bidding.
Malos, this was phone number 2 was the highest.
Sum of 2 lakhs payable to the learned senior counsel undertaking already been paid. Property having, however, not required to pay. Arrange for the full payment to be made. This was in October. Three months time was run. That's one number 2.
Yes, Malos.
Make the payment at the rate of 1,490 per share. Buy out the entire shareholdings of the appellants and Godfrey. So now they paid the amount?
No, Malos, they haven't paid the amount, Malos. In fact, on the last day of on 15th October 2025, what the court has recorded in order that we have to given the document to them, Malos. The document of the land are not with us, Malos. Because in 2015 itself, we have written to the SDM that if they are going to sell this property, so the whole.
Whatever photocopies they wanted was given them.
They might have this because we don't have.
I remember this, they made a mention or something like this about.
Because we do not have these documents of this land, because in 2015 itself, Milos, we have written to the SDM that they are trying to sell this property, so this should not be sold without the NOC of our NOC, Milos. So if it is the case, we were having the documents, so why would I have written in 2015 to the SDM, Milos? So from here, the whole issue started, and now after the intercept bidding, they have to pay this entire amount to us, Milos. So either.
But someone must have the title documents.
So Milos, either because Milos after they are the all this, so they might apply for the copies of that Milos. So this is the whole issue I left is that they have to pay the amount to us, and we are out because they are the highest bidder.
Yes, let us see what he has to say. Yes, counsel. Yes, please speak. Unmute yourself. He's unmuted or muted or.
My lords.
Yes.
My lords, all of this was canvassed before the court on the last date, and my lords, thereafter this direction was passed that at least, my lords, this company is only a landowning company. There is one major asset that it has. On the understanding that these title documents and this property forms the real value in the company, my lords, the inter-se bidding was done. My lords, on the last date of hearing, all of this was canvassed, and the court was pleased to pass the direction that at least the copy of those, including documents relating to the property of the respondent number 1 company, be provided to us so that we can avail financial assistance. My lords, I have my financiers lined up. Unfortunately, now the other party has moved an application for modification of this direction. My lords, if they say that the single asset
modification that they're asking for,
we have moved this application.
number 270713 of 2020.
We don't have that application at all.
Other than have it any miscellaneous day, Malos, if
70713. There is the office report.
It's mentioned in the office report.
Let
No
me put
other-
it in this.
In the end of,
They put the application.
Copy place to paper.
in the end of, before the ID.
I have only own documents.
27013, copy place to paper.
There you go. Copy placed with paper book. What do they mean by that?
I don't have the parts of this.
Senior advocate, this was last times.
We have.
Nothing else.
This is the whole paper book.
We find, don't say we find. The office report dated 23/2/2026 records that IA number 270713 of 2025 was filed on 27/10/2025 and states to the effect that the copy thereof has been placed with the paper book. However, we find no such copy on board. Registration verify and put up the same. Registration also ensure that what has been stated in the office reports is scrupulously carried out to avoid inconvenience and unnecessary delay. List on take it up on Tuesday. Tuesday it won't come up. We'll take it up on a Wednesday.
My lords.
Because it won't come up on 15th April.
Three papers.
Obliged. My lords.
Item number 8.
Plus,
Please, Manoj.
Plus, I'm led by Mr. Sunil Pandyanis, senior advocate. Plus, he's in some one part heard matter before Honorable NC-LAT. Plus, I'm requesting. So this is first time plus I'm seeking.
Oh, my apologies, maybe my fault because I took a Passover in the first one.
I don't know.
He was there, Milos.
It was there in the morning.
Yes, Milos. He logged in Milos in the morning.
You can't really prevent counsel from being truthful.
No, so I'm.
And our egos are sufficiently tough. I don't know about my other brother judges, but we won't take.
No, it will not take long is what I feel. I have to establish that there was a pre-existing dispute there, disputing that.
We'll take it up next Tuesday.
Anytime.
Request adjournment is sought by the Land Council for respond number 1. That is accordingly adjourned. List on next Tuesday. Matter shall retain its position in the list.
With,
13.
Is it only for today?
the interim order may continue.
Yes.
There is a
Interim order.
13.
Yeah. Because the rule.
Just one brief subject. Again, just to short the time. My suggestion was that we are ready to give up so far the areas are concerned.
They want a decision on merits.
Just a
because
moment.
it applies across the board.
For them. Otherwise, what I was suggesting, because it was on my suggestion, it will not be treated as a precedent in any other case, but leave it to my friends to argue.
But then again, they'll have to come all the way again. This case is
There
already
is no other
last.
litigation. There is no other litigation. We are free. Because this was only confined to the forest corporation, going to the forest department, isolated ones. But be that as it may, appendix.
Yes, sir, I have handed over the rules of forest guard.
What does the rule say?
These are the rules called forest guard. My lord, we have rule 7 for a moment.
Yes.
This prescribes method of recruitment and educational qualification. Method of annexure. Now annexure is at page. It is read as page 948 top lordship.
948.
Yes, sir. After 947 and 948.
Yes. 948.
Tabular farm
Forest
guards. Class 3, not non-selection post. Then Their direct recruitment age is 18 to 27 years. Bottom lordship, bottom column. Then may have passed the matriculation, etc., etc. Then on next page, my lords, we have
The flag page.
the flag page, my lords. This direct recruitment, 90%. Limited selection of class 4 employees by limited recruitment test.
I see direct recruitment.
Extreme right hand side.
Yes, direct recruitment.
Direct recruitment, 90%. Limited selection of class 4 employees by limited 10%. 10% post in the cadre of forest guard shall be filled up by limited competitive test out of the class 4 employees of the forest department and requisite qualification and experience given in column 9. Normally here one clause 14 is there of the rules, which is at 947. This is the power to relax. When exercising this power to relax, it says where the government is of opinion it is necessary or expedient to do so.
What is this?
That it is necessary or expedient to do so, it may by order for reasons to be recorded in writing relax any of the provision of these rules with respect to any class or category of persons. Now, at this, applying this rule, the government has taken this decision, I'm supplying you copy, yes. But that the forest corporation class 4 employees were also permitted to participate in this 10% category by this notification also.
This is also part of the recommendation in the
It
second.
is also part of recording second SLP. May read the subject filling up of vacant post of forest guard against limited direct recruitment in circular.
The second SLP.
And
appointment.
Let me have first paragraph at page 45, Lordship, for a moment.
And this is a rule of recruitment. No. Person post in the cadre of forest guard shall be filled by limited competitors from out of the class 4 employees.
Yes, sir.
Of the corporation itself.
It's a
Of the
department.
department.
Out of the department.
So the department people who come in
Yes.
will be entitled to the earlier period also.
Yes, they were entitled.
So then, what indicates that for them this is a fresh appointment?
Yes.
Where is the
You
indication?
did not even get them to resign from the corporation.
No, but
There's no resignation from the corporation.
Resigned from the corporation.
There is no resignation. Do not make, there's a specific finding that there's no resignation.
Resignation as such, the Honorable Court has recorded it.
Then where is the
But
resignation?
they
Who
have-
was the resignations from the corporation?
Not a single one.
But they were.
This whole irregularity arises because you want to do something
No, but
beyond the rule.
let me see for a moment. Page
As I said, most probably it would be to favor your blue-eyed boys.
but
So you have to open the door for everyone. Then everyone comes in, then you want to only protect your blue-eyed boys. So these people are getting some benefit. No, this is not what was intended. So you cut it short.
But this, if
This,
to see
to
this-
begin with,
Lordship.
this power of relaxation itself, the power is to relax a rule,
Yes.
not relax it in terms of bringing in a
And
new
look at it-
feeder category.
And look at it. You consider class 4 employees of forest department and HP Forest Corporation as one class.
They were.
And one LDR is conducted.
They were.
So
One
then
single exam.
the single exam for all of them.
them.
They
So
were.
then they should be considered, it's almost like a promotion and not a
It is not
fresh
because
appointment.
promotion. I may show to
No, look at your notification, your whatever this is. This is a
They are
notification.
considered as one class.
This document for a motive.
No, look at this rule.
Please, Your Honor.
This
No,
exception,
notification.
notification.
Please, Your Honor.
That treats forest, there is no separate apportionment of vacancies for forest department and forest corporation. So you treat them as one class.
We given them a fresh appointment even to.
How do you say that? Did you ask them to resign? Where is the resignation?
Resignation, that is not on record, but
There is no resignation.
No
It's
resignation.
not,
that is not on, but.
When that was directly an issue before the High Court, had it been on record, you would have brought it by way of addition.
Let me see how the High Court has dealt this issue.
High Court specifically notes that they were not even asked to resign from the corporation. No getting over it because you've not rectified that position. Had there been resignations, you would have filed them. So we take it that they were never even asked to resign from the corporation.
That I have to.
Yes.
No, so
Let me give me a week's time.
No.
Cabinet decision as well. Then let me have the finding of the High Court for a moment, Lordship. How the corporate scheme has been taken into consideration by the High Court, Lordship.
You went beyond the rules, opened this door, take the consequences now.
Let me have. Page 7. Let me have the judgment, Lordship.
Yes.
Para 13, I will read, Lordship. Another undisputed, Malad is here, Lordship.
Yes.
Another undisputed factual aspect of the matter is that state government had floated a Himachal Pradesh corporate employees pension scheme.
How are you concerned with that? They're not covered by this 99 to 2004.
If they are not covered, then they are not entitled for the pension of.
Once they come into the forest department as regular employees, they're part of your establishment. There's no question of drawing a distinction.
The service rendered by them in the forest department, we are giving them pension. They are getting pension because they have served more than 10 years of service. But so far
This
as
is Provident Fund pension. Provident Fund pension.
no, they are getting the CCS pension lot. They are getting two pensions at this point of time. One is provident pension.
That was not the subject matter of this
Here it is.
litigation.
Yes, your lordship.
Where is it considered in the High Court judgment?
But let me have this lordship. This
In the High Court judgment, counsel,
Please, Your Honor.
where is this issue considered? Have you raised this at all?
But we which we prefer before the Honorable High Court.
Did you raise it in the writ petition at all?
But in reply, we have said that they are getting they are
In the counter file?
they are not in the pension establishment because they are in the EPF.
Please answer this question, this issue with regard to they're getting double pensions.
But
You raise it in
at
your
that
counter file in the writ
at
petition.
that point of time, they were not retired, so they were
Right.
getting the.
So it's a new issue, it goes beyond that.
So,
So you take up that issue with the corporation, ask the corporation.
Now
stop
they are
paying,
retired.
can
Now they are
relitigate.
retired.
Now
Now they are
Now
retired.
they're retired, is it not?
they are retired in
You can ask the corporation to stop paying them that pension, they'll take it to the tribunal if they are.
Then
To
they are
the High Court or what.
their fund.
That goes beyond the scope of this litigation. That is not subject matter of this litigation at all. Having heard the learned counsel for the parties, we find no grounds made up
But
to
only one
interfere with the impugned judgment passed by the High Court. Especially petitions are accordingly dismissed. All of them are the same,
all of them are same.
same judgment also. Interim order dated 27/10/2025 should stand.
But so far as
This is the difficulty when you want to favor people, you want to play around with the rules. You do this, ask
24
for
years
trouble.
back,
Ask
24
for
years back,
trouble.
is a favor given to them only, to all of them.
They are the beneficiaries of the favor you wanted to show someone else. I have no doubt on that score.
But some.
This is all done to favor our own. This concept of our own, which we have in this country, this will be the death of us. This is all that goes on. Our own. Our own community, our own caste, our own people, our own blue-eyed boys. This is all that we want to take care of.
Well, one
It'll be the death of us.
Well, let me record that EPF pension which they are now getting, lordship.
We are not going to enlarge the scope of this. You are right to the corporation, ask the corporation to stop paying them that pension.
But since it's a dismissal, then that service will be counted for.
Where is that? We are not going into the issue of whether they are entitled to the corporation's pension.
But in High Court in case review, we have placed it on record.
Nothing.
But it will give us liberty to that extent that corporation may stop that pension.
Is the corporation even a party before us?
Here not, that is a difficulty.
Is the corporation a party?
But it is a.
Then why are you enlarging the scope of it? Then you advise the corporation, all of them are your people only.
Yeah.
Petitioner number 3 is corporation, I'm sorry, lordship. Petitioner
So,
number.
but anyhow, it goes beyond the scope of.
Petitioner-
Review, you could not have raised an issue which
It was
did not arise in the writ petition council. Mark it up with, we've already spent enough time on this.
But let's have my reply, lordship, and
Next.
reply we have said.
Next matter.
Please, lordship.
Lord, I'm being led by senior advocate K. Parmeshwar, so he's not available, requesting for a week.
If you wanted an adjournment, then you'll go to the bottom of the list, council. So you have an interim order?
No, there's no stay.
There's no. Council for the petition.
by 2 weeks.
Why are you in an urgency when they don't have an interim order? And council for the petitioner seeks an
Only
adjournment on the ground that the learned arguing senior counsel is not available to list on 12th May.
But only
That's too much to.
one submission in previous case, lordship. Because there are large number of corporation, it will apply to.
I see, you've done it with lot of corporations.
No, we have not done it, lordship, but it may apply, so but it may not be a.
We are not going to say
It's
anything
a
of that sort.
personal to these cases.
Not at all. If this is the situation in Himachal Pradesh, you keep playing around with the rules to bring in all these people contrary to the rules, then you face the
This
consequences.
corporate pension and this pension
You
are.
face the consequences. If you have violated your own rules and done this across the board, then you are inviting the consequences.
24 years back, if my lord only submit, lordship. only
Nothing more.
that it will not be a precedent.
No. Yeah, I'm not in the habit of just saying that.
Or by personal.
If I've decided a case, I've decided it for.
Because as a
That's
personal
it.
measure to these
No,
employees,
nothing more.
Employee may come, Lordship.
Absolutely not.
Please, Your Lord.
My lord, in item 14 and looking at it.
No need to write a matter, Chair.
My lord,
15?
item 14, I just have a request. Charge sheet is filed. They probably won't conduct the trial. So 12 May, my lord.
No.
Might be too much. Committee.
When you're asking for today is your day in court, you don't want it. The people who are waiting, we have mentions being made every day. You get your day in court, you don't want it, so be it.
The client request for an assistant.
Very well, then there any number of, how many people have we designated?
Tell the client.
Seniors are coming out of the woodwork in this court. Why do you need to have only one senior? You have a multiple choice now. Then.
And I heard that there are 290 more applications.
290. Tomorrow we are designating, I think, a few more.
I'm very particular about only.
Then that's your choice then. If unfortunately your senior does not give your case priority, you take it.
He's not available in the court.
Lords, I am seeking accommodation on two aspects, Lords, in this matter.
Well, you will also go to the bottom.
Lords, we are actually enjoying the fruits
Oh,
of the
there's,
interim
you're not
order.
going to, exemption from surrendering.
Yes, exemption.
That will cancel.
Lords, in a POXO matter,
You go to prison and then
just
you can have a longer.
Just difficulty, Lords, I apologize for that because the difficulty of 17 November order, which says that respondent number 1 and 2 have to file the counter.
No,
and thereafter we have to file the rejoinder. Now, that is the fact that one has filed the counter with some delay. Delay application is pending, which can be allowed, no difficulty, Lord. Respondent number 2 has not filed the counter.
Lord, this has in fact reached on the 7th attempt.
In the does not wish to file the counter. So, Lords, I can file my rejoinder, Lords, we keep it next week, Lords. I have no difficulty. They can retain its position, I'll file the counter within 1 week, Lords.
When did you file your counter?
Sorry, rejoinder, Lords.
Counter when we.
Counter was filed, my lords.
5th December.
Lord, there is an application for continuation of delay with them, Lords.
So what does that matter?
There is a question of
Counter. December they filed the counter.
So I was not aware that respondent number 2 was not.
That doesn't mean that you don't file your rejoinder to the counter. Argue, please. Argue, otherwise we'll vacate the exemption from.
Senior counsel is not present.
Sorry.
Please. Lords, I apologize.
There's a limit to the amount of charges that you expect from this.
That in a POXO matter, my lords.
Let
When
it
the High
day
Court
after
has
tomorrow,
convicted.
That's not an issue, my lords. We'll argue the matter. We'll never run away.
Let it be listed tomorrow.
After tomorrow, my lords.
Let it be listed tomorrow, my lords.
Lords, I apologize for my contact, my lords. It's not a case I will not apologize. I will certainly apologize. But I was under the wrong impression, my lords. I go down to this court for that purpose, my lords.
We never said that you will wait till both the respondents file their counter.
Lords, I was under the impression that I will file the rejoinder where I will file the consolidated rejoinder to both the respondents, my lords.
We never said that.
I agree, my lords. I was under the wrong impression. Go down to this court.
The lordship will recollect.
That my lords may have it next Tuesday, my lords. I have no
Lords,
difficulty.
in fact, lordships had issued notice on a very narrow scope of law. On the applicability of section 29 surplus of the POXO Act. I'll satisfy my lords, my lords. I'll not be unfair to my friends, but this envisages on a very limited scope of law. I'll argue that on the very aspect.
This is the section.
Section
29.
29, my lords.
So, my lords, let it be, my lords, next week, my lords, my learning.
My lords, tomorrow, my lords, not next week, because it would go down the list once again.
No, my lords, we retain its position, my lords. No, we never shy away with the arguments, my lords.
My lords, let it be listed tomorrow is my lords.
We'll
Most
take it up next
respectful.
Tuesday. It's coming up for the second term.
My lords, let it be on the top of the board in that case. Please.
Adjournment is sought by the learned counsel for the petitioner to enable him to file a rejoinder to the counter filed by the state. Needful shall be done within 3 days with an advance copy to the council officer. Based on next Tuesday, matter shall retain its position.
Much of
Exemption from surrendering granted on 15/10/25 shall continue to operate in the next year.
Much of it.
Item 16, please, ma'am.
Yes.
But these are cross appeals.
My lords, we are being led by senior counsel.
What is wrong today?
I apologize, my lord.
Everyone's already on vacation mode, is it?
No, my lords, he had an emergency.
1 week vacation, you can't take 2 weeks off.
My lords, he had an emergency and he had to fly out.
What is the emergency?
I am only aware that he had to fly out, my lords. I apologize.
Very short issue, so I can't say anything if they are saying emergency of the council, so but it's a very short issue, it may detain the.
What exactly are these booths?
The shopping area, see the shopping center, so the shop.
So it's a shop, is it?
The shop it is, so it's the issue.
But it has a veranda on the side.
We are just saying that during the auction, we calculated it wrong. We have not included that side veranda area. And that is why that reserve price was also.
No, but you can give it to him on that 10% extra, whatever.
It's not because of 10%.
Anyhow, the order passed by this court on 10th
Yes,
February
it says that.
permitted you to allot them an alternative booth also. Have you done that?
Your Honor, no, the order was actually to that they will give on 10% extra. That is of 2nd May 2023 order.
10th February 21.
Your Honor, thereafter on 2nd May 2023, there is another order.
I see. On
2nd May 2023.
2nd May 23.
But they refused the alternate plot.
I see, they refused.
So the order is actually in the
Make the payment in terms of the impugned judgment order. So that's the refund that you're supposed to give them, is it?
They have to pay the 10%
Amount.
on the amount.
That is the amount that was there.
That they have to pay. We are saying that actually the reserve price only will be increased when the amount, actually the area will increase. Our reserve price was actually calculated wrongly. And we are taking action against our officers. Because.
So you want to go for a fresh bidding?
Yes, because as per this, even the e-auction.
No, but his offer was far higher than your reserve price.
Uh,
He offered 62.4 lakh against your reserve price of 43.6.
Because it was not actually the area.
So what would have been your reserve price if you had taken the veranda or whatever, the corridor or?
Approximately more than 1 crore. In
1 crore.
Round I we have mentioned, because if the area have been increased, it's almost more the double.
The reserve price itself is 1 crore.
It could have been because it's a commercial property. So we are.
This is both are commercial, is it not? That other plot also was 22.688. That's a booth.
So no, that
Both are commercial booths only.
We have for that our officers have not included those side verandas in any of those plots. That is the issue which have come. If they have included the side areas, right now the area which has shown is 22.69 square meters. It would have been 45.38 square meters.
Do you have a plan of this?
The layout plan is there. Layout plan is there, Your Honor. It is on annexure P1.
Page?
It's page 23.
Which booth are we talking about here now?
27 number, Your Honor.
27.
Yes.
Yes. So 27 is here.
Below.
So how much did you get for 28?
Your Honor, in this auction, we have not actually, we have given all the areas of this, like area in this 22.69. That is wrongly calculated for every shopping area. So in fact, I have.
So all these, where is the notification which you issued for the auction?
E-auction notification is at page 26, Your Honor.
How many shops for auction?
Please, Your Honor, this. And then there were around 1, 2, 3, 4, 5, 6, 7, 8, 9, 9, 10, 12, 13.
What was the
14,
lease
15.
period? Lease period? Lease period? Lease period?
Lease period.
Is it a sale
an
or
allotment?
allotment?
No, it is the allotment.
Permanent
It's an
allotment?
Yes, sir.
Allotment on what basis?
Then,
Rent?
Auction.
no, it's
No, sold off.
sold off.
So in fact, I have filed one affidavit in May 19th May 2022, which I have
Oh, where is the actual notification? This notification which you are showing us is something else.
e-auction notice, Your Honor, and e-auction.
This page 26 is something else.
C2.
32.
30. 28 onwards. 28 onwards.
Started from 26 onwards. And the details of shop is actually at page.
Now, where are the details given of the shops?
Page 33, Honor.
33.
There's a chart given, the details of site is as under.
Both side.
And we have calculated.
Details of the sites is as under annexure 2. Where is annexure 2?
So your layout, I have mentioned that first.
So all those shops were put up for auction.
Yes, we put up all those shops and even the corner and this we have calculated.
You said 10 corners.
2.688.
We don't understand. How do you correlate this with your layout here?
Plan.
The plan. Look at the plan and look at what you said at page 33. 10 corner, 19 corner. I see the 10 is the corner plot. Corner plot.
Like
So you mentioned 27 corner. That's correct only.
yes, but the area then is calculated is wrong. That is the corner.
For all of them.
Yes, all of them.
What have you done with the others then?
Your Honor, they may have a compliance affidavit. There's a compliance affidavit of May 2022. 19th May 22.
19 May.
So anyway, the other person is not here.
No, but I just wanted to understand.
And that we have.
In compliance of order dated 25/3. That's the one.
Yes, Your Honor.
Yeah.
25.
Yeah.
Then,
What have you said in that?
in para 6, we have, I mentioned that actually the highest or even this side actually has gone the highest bid is 1.15 lakhs 40,000 for this as well. And I had given at all the.
This is for which plot?
I'm giving this. It is given. I had given that annexure.
No, what we are asking you is what you did with regard to the other plots which were auctioned.
There are two more. 19 was.
28, 19,
No, the
36. What have you done with them?
19 also was similar to this. And
What have you done?
yes, we have refunded the amount. These will be actually.
Where have you said that? The other corner plot people took back their refunds and kept quiet.
No, we have said that actually because in this both the matters we took it together and we said that okay.
All the others took back their refunds.
Not all the.
None of them went to court.
19 and 27 only.
Sorry?
There's a dispute of 19 and 27 only.
Why? What about the others? You meant what you showed us at page 30 indicates all the corner plots, and all of them you mentioned wrongly.
And moreover, what are you saying? The additional area you are saying is with respect to the corridor on both sides.
Corridor.
Or how does he use the corridor? The people use it, is it not?
Your Honor, there's a side window as well. There's an opening there on the side.
So see, there is a side window probably kept their wares are kept there. People walking through that can see it. It's a show window probably. So does that give you the authority to charge for that what do you call corridor also? Look at this. This is it. See, this is the portion there.
Policy. They can also.
You can't change your policy after the what do you call the no auction notice. Now look at this. You are saying that the what do you call the corridor should be included. Then why limit it to the corner plots? The other plots also should have the
All of them have the corridor, isn't it? They have an access to the corridor.
What they say is that there is a show window here. So
window.
This corridor is used by the general public.
This is all used by them.
Then why should you charge it from the?
So this plan lets the cat out of the bag.
Yes.
There's a plan and.
Because this indicates clearly what you are charging extra for now. The other plan doesn't indicate. I was wondering what this veranda is. I thought some veranda attached to the booth, which is private to the booth itself.
Merely because
that is not the case. This is a corridor. Corridor. It's a public corridor. How do you say that should be included in the booth?
Because there is a show window.
Is he going to charge people to walk across the corridor?
And he is not going to trespass into the corridor and put his wares there.
So, and why do you say that only with 19 and 27 you have an issue? What about the other corner plots? You auctioned the other corner plots also. Same issue should arise with those allottees also. Why is it that only these two are picked upon?
Your Honor, for 19, we have actually, for 10, we have received the corner lot. And for them, we have actually quite a lot. There's a list we have given how much amount we have received. With a price.
Look at page 33. You have several other corner plots which you auction.
Please, Your Honor, yeah.
Then how is it that you don't have an issue with any of those other plots? Only 19 and 27 are picked upon.
Your Honor, with others, we actually didn't say that.
You had a settlement. Some
They might have.
across the board settlements.
Not a process.
So perhaps we'll save you the trouble by dismissing the case today itself.
I'm grateful, my lords. It's just that we had also filed an SLP.
Oh, I see. What is your SLP form?
This is regarding the payment and 10% interest is what he is telling.
Very.
There are
Dependence.
10%,
That extra 10% which the High Court said.
yes, amount.
That if it's not available for the others, why?
They was for the corner, so I.
For the corner plot, some 10% extra or something.
Okay.
This on 21st April. Matter shall be given its position.
Please, Your Honor. Well, I also again take the instructions regarding the other corner plots, Your Honor. Right, Your Honor.
Number 17.
You should have taken the opportunity to say I am not proceeding with and
10%.
Matter pertains to compensation in motor vehicle accident. Your Lordship, on previous date of hearing, we have been informed by Standing Council of DMTC that they may enter appearance as of now.
No one has come.
this is why if the DP can answer registry to person.
Mr. Naveen Sharma, from Council. He is the Standing Council for Karnataka,
Yes, Your Lordship.
one of the designated council.
And for BMTC, Mr. R.S. Hegde.
And the name of Mr. R.S.
Hegde.
Hegde, Learned Council, in the cause list. This next Tuesday, matter shall retain its position.
Yes, my lords, the present matter raises a limited procedural issue. Whether in a proceeding arising out of a challenge only to the admissibility of evidence, the High Court could permit recall of witness for cross-examination. When, my lords, the witness had already been examined in chief, opportunity for cross.
What came before the High Court then? What was the proceeding before the High Court?
My lords, in the High Court, they were only challenging the evidence of the performer defendant. And in the order, while they were saying that they would dismiss the matter, they're ready to withdraw the matter. They want to cross-examine it.
R2's evidence was closed on 3rd January 2018. What was the application filed by the respondent thereafter?
He filed an application saying that defendant number 2 cannot be examined.
It cannot be examined
Because
after the closure of the evidence.
No, after the closure of the, during the closure of the, after he made his statement, then I informed the court that I am going to challenge it before the High Court.
On
During
which
that,
date did you inform?
That was on 8th of December, Your Lordships.
Of which year? 8th of December 2017.
8th of December 2017.
You said that trial court records that you did not cross-examine.
On 16th of December, I informed that I'm going to file an appeal before the High Court. That is a writ
Where are these orders? 8th December. Let us see the 8th December order.
My lords,
Page 63, my lords.
2018.
Not even in the prayer, it was not mentioned that they would recall the witness. It was solely that on the admissibility of the.
My challenge.
There is a sociological theory.
Eighth December first, please.
8th December.
63.
Page 63, my lords.
Plaintiff and witness are
The
present.
plaintiff witnesses are present.
Submits that application. Hence, he will cross-examine on next date. Time is given for cross-examination. So you ask
on the
for an
next-
adjournment to
yes.
cross-examine the.
On the next date, I inform that I am going to.
Let us see what is recorded. Presence noted for all parties.
The second paragraph.
Why did you do all this unnecessarily?
He refused to cross-examine. So you refused to cross-examine?
Yes, yes, because I challenged.
No.
I challenged it before the High Court.
Please understand this. What court says is that earlier occasion you said that I'll cross-examine on the second day. On the second day, you come and say that no, I'm not going to.
I'm going to challenge it because.
Then you should have challenged it then on the 16-12.
Now again you want to.
I challenged it
So you're going back and forth like a pendulum.
within a few days.
If 8-12 you had that feeling,
yes,
you asked for an adjournment. You should have challenged it before 16-12. And this is a 2018 what do you call petition before the High Court.
Yes, Your Lord.
True, it is immediately on January 2008.
Thereafter, my lords, Your Lordship, it was immediately challenged within a few weeks, my lords. It was immediately challenged within a few weeks.
Why don't we do it on terms?
It will take 2 dates, my lord.
Why do you want to stay?
It will take 2 dates, my lords.
On
2 dates.
It was closed in 2017 and they want to recall it in 2022 again.
It will take 1 or 2 dates, my lords. It is
Because
because
3rd January 2018.
2018, my lord.
18. 3rd January
2018, my lord.
Evidence of D2 is closed. So
At that time, application was pending. At that time, my writ petition was pending for the High Court.
Opportunity was
Did you have a stay before the High Court?
At that point of time, on 3rd of January, there was no stay, my lords.
When did you get a stay?
As far as High Court is concerned, even now the trial is pending at that.
Also,
We're
my
asking you.
High Court, we did not get an opportunity to even cross it. It was given in an oral prayer that they would be granted the opportunity to cross them.
You are present there. You should have objected to it.
After D2, was anybody else examined? After 3rd January 2018, any more witnesses examined?
Are you aware that?
That might cause some.
The suit is still pending.
Suit is still
Stays
pending,
there.
my lord.
Stays
Suit is still pending, my lord. Suit is still pending.
Stay in 20.
Now, what happened when the matter was pending before the High Court? When the matter was pending before the High Court for 3 years, 4 years, what happened to the suit if there was no stay? Can you tell us?
The evidence was still going on, but as far as R2 is concerned, he was.
Okay, so the evidence.
It was, other proceedings were going on in the trial court. As per my instructions.
So other witnesses were examined.
If there were other witnesses, they may have been examined, Your Lordship. I'm not, can't be very sure.
We didn't grant
I can't
stay
be
of
very
the,
sure.
I stand corrected. I thought there was a stay operating. We only said effect and operation of the impugned
Of
order.
the impugned order. So as far as R2
Therefore,
is
the
concerned,
trial continued.
the trial continued.
Then what remains?
The trial is continuing, my lord.
Can't say that. Having challenged it, you can't do. With liberty to cross-examine.
Cross-examine, that's it, my lord. It will take 1 day.
That's not fair conduct.
For all this.
Your Lordships, in case, if, Your Lordship, I could not have cross-examined him earlier.
This kind
Because
of
blowing hot and cold.
I could not have been,
Blowing hot and cold. First you said you will examine.
In that case,
Then
Your
you said you
Lordship,
will challenge. You challenged it after 4 years. Say I'll cross-examine. What
not after 4 years, immediately thereafter I had filed. In fact,
2018 to 22, you kept, the matter was pending, is it not?
No, for a lot of time it was pending because of COVID also, Your Lordship.
Whatever it is.
It wasn't, Your Lordship.
Trial was not
The
stayed.
matter remained.
Trial was not stayed even by the High Court,
No.
nor by this court. So there's no question of.
So as far as R2 is concerned, Your Lordship, in all fairness, I may be allowed to.
Fairly granted. Challenge.
Your Lordship, if I were to cross-examine him earlier, I would have forfeited my right to cross-examine him.
Order, not judgment. To the oral order dated 2012-2022, passed by a learned judge of the High Court of Judicature at Patna in civil miscellaneous jurisdiction number 2 of 2018. Full stop. By the said order, the learned judge allowed the respondent number 1 herein to withdraw his petition and granted him liberty to cross-examine defendant number 2. Full stop. We find from the record that the matter had come up before the trial court of the learned sub-judge Roman 2, ACJM Roman 2, Patna. In the matter, don't say the matter, title suit number 753 of 2011 had come up before the trial court of the so-and-so on 8/12/2017, and on that day, the learned counsel appearing for respondent number 1 stated before the court that he would cross-examine defendant witness number 2, Viz. Alok Kumar Gupta on the next date. Time was accordingly granted by the trial court, and the matter was taken up on 16/12/2017. Stop. On that day, the learned counsel for respondent number. Before that, I have to give you one more. Where is the 512 order? 5. But remove that from the record. What did I say?
We find from the record.
We find from the record that on 5/12/2017, the subject matter of the present proceedings with title suit number 753 of 2011 came up before the trial court of the learned sub-judge Roman 2, ACJM Roman 2, Patna. On 5, I said the date I already mentioned.
Yes, Lord.
On 5/12.
8/12.
5/12, first one. On 5/12/2017. On that day, the learned counsel appearing for respondent number 1 objected to the examination of pro forma defendant number 2 in the suit, as a witness. Full stop. The trial court, however, noted that any party to the suit can depose to support his case or to support the case of any other party, and therefore it did not find any merit in the petition. The matter was accordingly adjourned to 8/12/2017 to enable cross-examination of pro forma defendant number 2, Alok Kumar Gupta. Full stop. On 8/12/2017, the Learned Counsel for respondent number 1 informed the trial court that he would cross-examine the said witness on the next date and sought time. The matter was accordingly adjourned and was taken up on 16/12/2017. Full stop. On that day, comma, the Learned Counsel for respondent number 1 informed the trial court that he wished to file a case before the High Court against the earlier order dated 5/12/2017. The trial court noted that the matter had been listed. The date is wrongly noted there. It must be the second date is 8/12, not 5/12. Noted that the matter had been listed before it on 8/12/2017, and on that date, the Learned Counsel for respondent number 1 had stated in the open court that he would cross-examine the witness Alok Kumar Gupta on the next day and prayed for time. But having done so, but despite being asked multiple times by the court, comma, he refused to cross-examine the witness. Full stop. The trial court also noted that despite passage of 10 days of time, no appeal had been filed before the High Court. Full stop. Observing that no party could be allowed to change its stand on every day, comma, the trial court adjourned the matter to 3/1/2018. Next fact. On 3/1/2018, the evidence of pro forma defendant number 2 was closed. This being the situation, what did you challenge before the High Court? 5/12/2017.
5/12/2000. And on 3rd of January,
This being the situation,
petition was pending, my lords.
Respondent number 1 filed civil miscellaneous jurisdiction number 2 of 2018 before the High Court of Judicature at Patna, assailing the validity of the order dated 5/12/2017. It appears that the matter was kept pending for nearly 4 years.
Well, the earlier order, 5/12/2017.
Was to the 5/12/2017
Yes, Your Lord.
order.
Yes, Your Lord.
COVID started in March
March
2020, not in 2018.
Yes, exactly.
COVID
That
seems
time-
to have become the be-all and end-all excuse for everyone
Your Lord,
who has some delay to explain.
3rd of January, when their evidence.
Counsel, do not interrupt while we are dictating, please. What did you challenge? That is all that we wanted to see. 60.
That is there at page 68, Your Lord.
Right.
Certified copy of
Or quashing of.
It appears that the matter was kept pending for nearly 4 years, and we find from the impugned order dated impugned oral order dated 20/12/2022 that the Learned Counsel for the respondent number 1, comma, having argued for some time, comma, sought permission to withdraw the petition, reserving liberty to cross-examine defendant number 2. We fail to understand the changing stances of respondent number 1 from time to time. It is not open to a party to adopt this pendulum-like stance to suit his own interest. Full stop. We may also note that the evidence of defendant number 2 was closed as long back as on 3/1/2018, and there was no stay of the trial, be it before the High Court or by this court during the pendency of this special leave petition, and the trial would have progressed further. Even if it had not so progressed, it is too late in the day for respondent number 1 to have another change of heart and again seek to turn back the clock so as to be permitted to cross-examine defendant number 1. We find the conduct of respondent number 1, defendant number 2, not 1. We find the conduct of respondent number 1 to be completely lacking in, we find the conduct of respondent number 1. Don't mention that again. It might impact this.
Your Lordship,
I mentioned the appeal is accordingly allowed, and the oral order dated 2012-2022 passed by the High Court is set aside.
the only difficulty, my lords, is that now that evidence will be admissible and I won't have a right to cross-examine, my lords.
Your own mistake.
But your Lordship, in that case, I would have forfeited.
16, 12, 10 times the High Court said. Despite being requested 10 times,
Your
you
Lordship,
were adamant.
On 3rd of
How will be
January,
the
I filed the
consequence?
writ petition, my lord.
Sorry.
Much obliged.
Limited notice.
Well, it's,
Yes, Maharaj.
before my learned friend
May I
starts,
just hand over?
just one thing. There is one document which is in Marathi, which was part of the proceedings before the High Court. It's a one-page document. I can bring it on record. It may be of some relevance, if my lord so.
You had ample time to.
Well, as I understand, I could not fetch the document.
This matter has been pending since April 2023.
Yes, my lord.
And
Well,
what have you been doing all this while?
Well, I have filed my counter. I could not get hold of.
2 years you had time.
Well, I could not find this
decide
document.
what is relevant, what is not relevant.
Well, I could not locate this document is the only thing. I have filed everything else with my counter. This form the part.
Now you have located the document.
Yes, Malaj, I have.
You have it with you.
Yes, ma'am.
When did you get it?
Well, it's in Marathi.
When did you get it?
Everybody is here.
Yesterday. Yesterday.
Because I can.
Anyone who understands Marathi.
Because I can do that.
He can read it.
Very well, you can read it. Very well.
Very well.
We'll go by whatever Mr. Deshmukh
says. Very well.
No point in giving it to us.
Give it to Mr. Deshmukh.
I have.
And
We'll
you got
make it part of the record though, but anyway. So that
It's a small paragraph and you could have translated it and brought
Well,
it.
I tried.
You don't know Marathi?
No.
you don't know Marathi.
No.
All right. Then how do you know it's relevant then?
Well, it formed a part of the High Court below.
No, but how do you know it's
and
of relevance then? If
Well, it's pleaded in my counter before the in my additional
So
submission.
you know what the substance of it?
Yes, ma'am. Yes.
What is it supposed?
Well,
What is it supposed to say?
I had just informed the petitioner hearing that there were no posts available to give them. This is a letter informing them of that.
It's on 14th August 2001.
Yes, ma'am.
Saying that no posts are available. Then is that what it says, Mr. Deshmukh?
Yes, Maharaj. But then the finding on the record is that the sanctioned posts
Were available.
available from 1996 till 2007. This letter my learned colleague refers is of 14th of August 2001.
And it says, what exactly does it say? Can you just
Maharaj says, it says that your proposal was received by us for the purpose of granting permanency. That was forwarded to the office. But since there is no provision, we could not finalize it, and that's why
no, but it also says no posts are available.
no posts available, Maharaj.
It also says that.
Yes.
Why does he say that limited notice?
The notice was limited.
The first order.
First order, Maharaj. 24th April 2023 order. The notice is limited only to financial benefits.
25?
24th of April
24th
2023.
That
You
order
don't
is
have the
not-
first order. Oh,
that order is not.
not there. It's the first order. The notice limited to consideration of the. Yes, Mr. Deshmukh.
May I just hand over one more? Just to give your lordship a brief idea. So these are all undisputed dates which are relevant to your lordship's consideration.
Yes.
May I just briefly take your lordship through it?
Yeah.
So admittedly,
from 1982 to 1984, the petitioners were working through a contractor. Thereafter, it is also not in dispute that thereafter both the petitioners were working as telephone operators to operate PBX exchange with effect from 1st of June 1984, not through contractors. There was direct employment. That is referred at page 45. 4th of June 1996, the superintending engineer of the respondent has sought sanction for the post of telephone operators, and accordingly 2 posts were created sanctioned through the office order. 8/4/2023, petitioners filed complaint ULP respectively before industrial court, contending that though the posts are sanctioned, the petitioners are neither appointed nor given permanency on the said posts. Evidence is laid by the parties. The respondent, which is a state corporation, it does not lead any evidence. 26th of September 2013, the industrial court allows the complaint. It renders specific findings that the respondent has engaged in unfair labor practice, and the findings are to the extent of work is not disputed. Posts are admittedly sanctioned in 1996, which is at page 51. Entry in service not on the basis of fraud, continuously worked and not through contractor, and the respondent ultimately is directed to confer permanency benefits along with consequential monetary benefits to each of the complainant with effect from 4th of June 1996 and to pay arrears after fixation of their pay in the pay scale prescribed within 6 months from the date of the order. And in addition, they were granted compensation of 1 lakh each by way of compensation and 10,000 by way of cost. Now, this was challenged by the respondent state entity before the Honorable High Court, and both the petitions, they have been allowed by the impugned order. Now, there's a slightly fault on. There's a slightly fault on our part as well. When we went for review, the ground was taken in review that the petition was not argued before the court.
Not argued.
That was the ground raised, my lords. So that was the ground on the basis.
In the sense that.
In the sense that there were no arguments made.
And the petition was allowed.
And the petition was allowed.
Blame the lawyer. Or the
blaming the court, is it?
Or the lawyer.
It's both. The review, my lords, has been rightly dismissed, and my lords, I must say, my lords, since neither of your lordships were part of the bench issuing notice, it was this.
I was there.
Your lordships were there. Just to briefly recapitulate, this was the very reason, the conduct, which compelled the lordships to issue only limited notice in the matter. And that's why, my lords, the findings with regards to dates about admitted work rendered by the reference court, they would be pertinent. Which are at page number 50 onwards.
Financial benefits means limiting to financial benefits means no, not the.
The age of superannuation.
Yes. Admittedly. Not then the High Court has 2004.
So they were never made permanent.
No, they were never made permanent.
Continued continuously.
Yes, sir. That's an admitted fact.
Till the age of superannuation remained in service.
Yes.
That is for that is precisely for this Act. Maharashtra Registration of Trade Unions and the Prevention of Unfair Labor Practices Act. That's a specific act. MRQ and
in fact, recently your lordships have also gone to an extent of saying that even contract-based laborers, if they are continued for years together, then
this court has said this way and that.
Why does the High Court hold against you?
The Honorable High Court, could your lordships come to paragraph number 16 at page 10. In fact,
Clearly unfair labor.
That is from 1996 to 2007. In between, as mentioned herein above, no post of telephone operator has ever been in existence. It cannot be said that the post was in existence.
But they used you as a telephone operator. Without having a sanctioned post of a telephone operator.
So they continued us.
If there was no EPABX, probably they could have raised this contention. There was no. But
I understand.
when there is an EPBH, how can you say that you can't, there is no post of.
What department is this?
You have a car and
MSc
no driver. You
MA?
have a car and no driver.
Maharashtra State Electricity Department.
Electricity.
Electricity Department.
Give a car and no driver and appoint somebody. And what is an unfair labor practice?
Was continuation,
Granted any
Definition.
such declaration.
sorry.
Definition in the act.
No, does the High
In the
Court
Act.
doubt that you actually worked as a telephone?
No,
No,
ma'am.
no.
It doesn't
High Court
doubt.
doesn't doubt. It doesn't doubt.
They say that
It doesn't
there is
doubt.
no telephone bill. Good. But there.
Let's 2 to 3 submissions here.
Did you not use their services as telephone?
I did
You did.
use their services as contractors.
There's no contract after 84.
I'll just explain that. Till 84, they were working under the contract with SN Bhosle.
82
After that-
to 84. After 84, you took them on directly.
The first petitioner was contracted and the second petitioner was contracted through the first petitioner.
Through the first petition.
Through the first petition.
What is this system?
I understand. If I may just.
So even before outsourcing hit us, you already adopted that concept, is it?
From 84, they were serving till 96 when there was a talk of sanctioning 2 posts for the 2 individuals. There was a company-wide mandate banning any hiring. I have put that on record. I informed them as well that there is no post available. Thereafter, in 2007, I removed the posts altogether. There have never been posts for telecom operators.
Forget it.
You don't have telephones. EPBX system is not there.
It was also supplied by the contractor itself.
You were using it. Though.
Yes, Malaj. They were supplying it. But Malaj, unlike any other jurisdiction or any other place, there was
that state instrumentalities do this and come before the court and try to say that this is a valid practice. You're a state instrumentality. What?
Malaj, my brief submission is: firstly, there were no posts. Therefore, an order.
There were no posts because you did not create them, despite having a need, despite having someone actually discharging those functions. Who is responsible for there being no posts? You are squarely responsible.
However, I had informed them just the fact that they were.
Why did you not dispense with their services?
Just
because you needed the telephones, you needed just PBX.
If I may submit, just because they.
Now the only question is, what relief do we grant you, Mr. Deshmukh?
What has been granted by the
permanency?
Oh.
What is this permanency?
Permanency, whatever has been granted by the.
Whatever in my submission granted by the industrial court, that can be.
And they should be given pension also.
Pension.
Also.
When did you attain the age of superannuation?
In 2004 and 7 is what this.
4 and 7.
4 and 7.
So then you won't get pension. If it is from
82.
84 to
84. No. Your permanency is only from 4696 by the tribunal.
Tribunal grants you only from
46. So then you won't get pension.
Then you won't get.
You can't do anything about it. You have not appealed against it. So then nothing can be done.
So only the monetary benefits.
Only the monetary benefits.
And it's not much. 8 years monetary benefits. Give it and finish it off.
I obviously.
There's a limit to exploitation by the state of.
And if
just because people are unemployed in this country, people take advantage of one thing. But when the state and its instrumentalities join on the bandwagon and exploit people like this, we have to draw the line somewhere.
If he had challenged it, we would have granted from 84.
Had they challenged it, perhaps you would have had to face the music.
I understand, Malaj. Our limited.
Be satisfied with getting away lightly.
Malaj, our limited.
After this kind of exploitation.
Malaj, our limited submission was that we.
The order.
My lord, this is an MSCD case, my lord. Related that despite such consent object when granting consent under the Motor Vehicle Act 1982 to ensure just and fair is paid to aggrieved party. My lord. This is
In that case, how much was the amount?
My lord, Justice Honorable Oral passed the judgment. My lord.
Concern you can't.
6,17,000.
I agree with that.
6,17,000. 11 lakh.
In my humble submission, my lords, even if we take this into account, the discretion given by the Honorable Court as well, my lords, the awarded amount awarded by learned MECD was 3,34,000. Honorable High Court, after taking into consideration every aspect, my lords, had awarded double
75 lakh.
50% of the amount. If we see 175, it comes about to 350.
No, the appeal was by the claimants.
Appeal by was the claimants. Enhancement. They were even present. The language.
No, how can the what do you call court reduce it?
No, my lords, 334 they had awarded over and above 175.
Okay.
3.34.
Over and above they awarded after taking into consideration every aspect.
My lord, having another judgment passed by this Honorable Court of the Constitution, my lord.
No, but now on what basis are you asking for further?
The kindly see the judgment. Another judgment passed.
No, forget the
This is
judgment.
right.
The discretion of the.
My lord, no. My lord, no.
He was 22 years old. What was his educational qualification?
My lord, he was doing
He was
driving.
working as a driver.
Driver and the monthly income did not considered by the court below, my lord.
What was the
This was
year
in
of the accident?
2009.
Yes, my
Year
lord.
of the accident
2000.
You have a driving license.
My lord,
Driving license was shown, or how did you prove that he was a driver?
my lord, kindly come to the page 14, my lord.
14.
The paymaster journalist.
He was examined.
Yes, my lord, 14.
The employer was examined.
Paymaster, my lord, Raj Kumar Mahanti, journalist. 14, page number 14.
Was
This is
driving
certified
a
as
driver.
Jyoti Prakash Panda, agent
Was
of-
he examined?
Yes, my lord, it is a statement before the MSCD, my
He
lord.
says 5,000.
No, this is a certificate.
He says
My
5,000.
lord,
Oh, 5,000.
submitted before
No, he
the.
said 5,000. How much?
He himself is saying 5,000.
My lord-
The employer says 5,000. How do we
My
get
lord,
it?
did not consider 3,000 considered by the courts below, my
I
lord.
see 3,000 is correct.
Yes, my lord, considered by the courts below. My lord, come to the page
So monthly salary would be
18, my lord, come to the page 18. My lord, 18,
5,000 into.
para 7, my lord.
You are a bachelor.
Yes, my
He was a-
lord.
he was a bachelor.
4 dependent, my lord.
So one half to be taken.
One half to be. Even in that case, 175 would suffice.
50%. 30,000.
5,000 into 12 into 50% into
Is 18.
18.
22 years.
22. Then what is the future prospects?
40%. Future prospects not taken into consideration. at
Future
all.
prospects is how much? Future prospects is
40,
how
40%.
40%.
40%.
Future prospects were not considered in my.
40%.
So 140%.
Mental agony also, my lord.
140.
Milos, if Milos may have.
Wait.
Then the claimant is the father, mother, who?
My lord, father and brother and sister.
Brother and sister, they are not entitled to.
My lord, they
No.
were
They are
minor.
not entitled.
My lord, they were minor at that time.
Whatever it is, they are not entitled to what do you call?
My lord, unmarried sister
Compensation.
also. Unmarried sister, my lord.
Father is there.
Father is
My
the
lord, unmarried sister, my lord.
unmarried sister.
He is
and
not
all
supposed to be taking care of his family. The father is there. Father provides for the
Well,
children.
that's
Brother is
okay.
not expected to.
My lord, kindly, my humble submission, they were minor that time, my lord. Kindly see the
Even then. 40%.
Paid 50.
On 30%, it will be 40%
See,
increase.
My humble submission, my lords. If these consent orders and consent decrees, my lords, are turned around,
See, what is the consent? Look at these people. They are marginalized people.
My lords,
And you
But
can't
the
say that the High Court.
council agrees.
Council agrees to it.
it was proposed to
These kind of matters, the party would not even be
the
present.
language of the order.
It
we
is
all
not
know
even
that-
as if the High Court records that the party was present, council consulted the party and then consented.
Not only that, High Court Council.
The
We
council,
know High Court Council.
High Court council feel very magnanimous
Hello, that-
consenting.
I have
They
the-
don't want to displease the judge, so they just agree.
There are judgments in the regard.
See, that is,
No,
I remember,
really.
see what happens is, at my time, the MSCT lawyer gives you have paid 1,000 rupees. Be conscious of the reality. High Court lawyer has absolutely no contact with the client.
Let me take instruction in that regard, my lords.
No.
Pass it over, my lords.
Nothing.
Order, sir. Thank you.
This company paying or the
Insurance company, sir. I am for the insurance.
you offer?
Madam,
They granted. Appeal back. Or no?
I mean, that is island. That is only template. I give it to them. My love. 856.
My lord, mental what they have got there
Come on.
is 5,000 only, my lord.
Be happy that you are getting on 8 lakhs. This is a mental agony and all that. Nothing.
My lord, another request, kindly mark my appearance, my lord.
That of course.
My lord,
Why are you not the council on record?
My lord, I am an admin council, record not record. My lord, I'll
Give your name, we'll make it.
my lord.
my lord, what they are claiming is 5,000 only. Monthly income is
Yes, 5,000.
5,000. That is what it.
public.
What's the certificate? There was no need to doubt it. In 2009, where did you get a driver for 3,000 rupees?
My lord, I am aware. The only thing is this matter also went to Lok Adalat.
One case said that coolie gets 4,500. So I give 500 incremental increase in every year.
Please, Lordships.
Yes.
Please, Your Lordships.
This is, my lord, a dispute between brother and sister, my lord. The dispute arose, my lord, with the execution of an alleged will, my lord. The brother
Execution?
of an alleged will, my lord,
Very.
allegedly executed by the deceased father, my lord. The brother comes up with a case, my lord, that the father has executed will in his favor and has transferred all his properties in his favor, my lord. As soon as sisters come to know about it, my lord, one of the sisters, my lord, filed a suit for declaration.
Only one sister.
One sister was.
The other two sisters are not joining you.
They are with me, my lord. They are supporting me, but they were arrayed as defendants.
How many sisters are there?
There were 3 sisters, my lord. One
Altogether, including you.
Yes, one deceased, my lord. Now 2 deceased. One is surviving.
One is?
2 are deceased.
Two are deceased.
One is
You're
surviving.
the surviving sister.
Yes, and mother was also one of the defendants before the High Court.
Mother is also no more.
She no more, yes. My lord, and the property, my lord, was bequeathed in favor of defendant number one, my lord, who is respondent number one here. The entire property goes to him, my lord. Even mother doesn't get any share out of it. So that will was
That was
challenged.
the self-acquired property of the father.
Yes, my lord, that the finding is to that effect, my lord, that the property.
You claim that the property belonged to your mother.
Yes.
But you're not able to prove that.
Yes, my lord.
And the father willed it.
His father, yes, my lord. Father.
And there's no proof of this being ancestral property.
No.
Joint family property.
No.
So it is his self-acquired property.
Now I have to take it as it has been.
So if it's self-acquired property, he is entitled to will it to whomever he wants.
No, but that's right, my lord. But my question is something different now. Why I'm before your lordships is on some different ground. The first issue that I'm raising before your lordships is, if your lordship would see my prayer, my lord, in the suit was limited only to the question of execution of the will. I said that the will which has the thumb impression of my father, that thumb impression doesn't belong to my father. It's not by my father. So that was
the attestors must have been examined.
Yes, that's right. So the dispute was with regard to the execution. The trial court, my lord.
Did you get any admitted document wherein his thumb impression was there? You're not able to prove.
I am more aggrieved because of the appellate court's order.
What does it say?
Yes. The trial court's order before that. I really have trial court's order. Trial court's order is at page 66.
66. Yes.
The issue, my lord, which is at page 17. Issue number 2 and 3, my lord.
2 and 3.
Yes. Does she further prove? She means the plaintiff.
You.
Yes. Does she prove that defendant number one prepared a bogus will related so and so as contended?
Not proved.
Yes. And does defendant number one prove that the deceased uncle, that's the father, my lord, on so and so executed a registered will? So the issues were limited to the execution of will. Now,
sorry?
The issues were limited only to the execution part, my lord. Now, kindly have the finding, my lord.
Why does the trial court record does not
survive issue number 3?
It has to be proved.
No.
Yes, I'll show that.
Was it not proved?
Which one?
The will was it not proved?
Yes,
So
the
the
trial court did not go into that question.
Trial court.
Does
Is
not
the plaintiff
survive.
entitled to permanent injunction? That was found.
Kindly have finding
As
it
per operating, partly
Who
alone.
is examined? The attestors of the will?
Yes, they were examined, but only to the extent of execution.
That is all that is required.
Whether the will was free from false suspicion. This part was never came, my lord.
That is for you to prove. Once the will stands, the execution of the will stands
That was
proved.
not my prayer altogether.
Suspicious circumstances you had to raise.
Certainly, but I only questioned the execution of the will. I said that the will was not executed by
Well, that should disproved by the attestors'
yes.
evidence.
But not in appeal, the appellate court went on to decide the legality of the will.
No,
which was not read at all.
Counsel, you are the plaintiff.
I am the plaintiff.
First defendant claimed will.
Yes.
But the trial court decreed the suits restraining him from alienating or disposing the property.
Yes.
On what basis?
On what grounds?
Yes, my lord. Because the trial may read that, my lord. I will read that portion only.
And your declaration saying that the will of Sam was declined.
That's
That itself is wrong.
He allowed me to read
That
that.
That is the reason why both of you appealed and they succeeded, your appeal fails.
He has not even appealed, my lord. He has accepted
Both-
the trial court's order.
No. Both of you appealed.
And the both of
Against this
both of
injunction
us
part of it, he appealed.
He also accepted trial court's order. How that I'll apprise your lordship.
What is there to accept? The part that is in his favor, he accepted.
And
That
allow me to read this part.
the will is proved.
Issue number 2, finding with regard to
Will
issue
is
number
proved through an attesting witness.
will execution is proved, my lord, not
Then
legality.
where is the question of
That is the will.
legality?
That is the proving of the will, is it not? The
Where is the
execution.
question of
Then
legality and
What is
It will get clarified. my lord.
63 Succession Act, 68 Evidence Act.
If your lord-
it is for you to raise a suspicion on the will. Otherwise, it is the testator's will, not our subjective satisfaction.
That's right. But my lord, admittedly, the suspicion is admitted, my lord.
What suspicion?
Yes, he has admitted that he has taken active part in execution of the will.
So what?
He was
What's
present
wrong
at
with
the time of execution of will.
Mere
There's
presence
nothing
is not sufficient.
Not where he,
The benefactor,
yes.
the beneficiary of the will being present is not by itself sufficient to invalidate the will.
Active part. And the exclusion part, you know, that has also not been considered.
Is he a scribe? Is he one of the attesting witnesses?
No, he was present there.
What do you mean he was? Then what is the active part that he did? Did he dictate the will? Did the attestor say yes? He was standing there and dictating the will.
There are many other factors.
No, you're just building up your case as you go.
No, kindly allow me to read this part.
Which part?
Page 76, my lord, at the bottom. This is trial court's order, my lord, in the finding.
The trial court's order is even more strange.
Yes.
Having held against you, then they grant you a favorable order, injunction.
May I read that? Issue number 2. Issue is on the point of legality and validity of will. It is precarious to note that the legality of will is not under challenge.
Precarious to note that the legal.
Crux of the suit.
What is the look at his pleading. Thereafter, he was not at all going to leave Tanaku, Tukaram, and defendant number 1 or anybody else.
It's not good.
I don't know. Defendant number 1 was never doing any work of supervision at plaintiff. Defendants and deceased and Garam brother. So, defendant number 1
is the brother.
May I read further?
See, the mother was with you.
This artistic license, is it on your part or did the learned judge coin these new words? Crux being not CRUX but CRUCK.
There may be some typing this thing.
Some typing mistakes. Very well. Or are you claiming some copyright by changing it? Manupatra does this with our judgments. Now you seem to be doing it with this poor trial court judges.
Maybe there is some typing here. So the crux of the suit is only to the execution. Plaintiff has not put challenge to even if the will is executed, it is not legal and binding. Our interplaint and the prayer clause is that will has never been executed. Hence, it is not legal one. Issue is in fact redundant issue. It is framed on pleading of the defendant that it is perfectly legal and valid will.
Whenever he was sick again, he called the defendant, but he did not come. See, he says that despite defendant not taking care, see, there is no this thing of coercion or anything. Your specific contention in the plaint is that the defendant number 1 never looked after the father.
Yes.
So there is no contention of coercion, there is no suspicion. Despite his not looking after the father thought that his son should get it. What can we do about it? It's a
Your plaintiff stated that they have stayed along with.
We were held to be co-sharers, my lord, in absence of any declaration.
How do you get a status of a co-sharer when it is an absolute property?
Lord, kindly have the next paragraph.
That says absolute property is willed it to the son with your execution. How do you claim it?
Yet to be whether the properties belong to the testator.
There's nothing more to be said.
But kindly allow me just once more. May I read this paragraph?
Which paragraph?
This same paragraph, paragraph 14, the next part. Defendant has not sought declaration in the counterclaim, neither plaintiff has whispered legality of will, even though it is executed. Restricting myself to the strict legal principle, I did not decide the legality of the will. The trial court says, my lord, that the plaintiff has not even, the defendant has not even.
There's no question of legality of a will, counsel. It is not open to the court to say this is morally wrong. He ought not to have excluded his daughter. What is this legality of a will? Once the will is proved, the only issue is whether there are any suspicious circumstances surrounding it. The will's terms cannot be subjected to some scrutiny on the ground of equality, Article 14. I don't know what this legality of the will is that you're projecting.
That is distinct from the execution.
It has to.
There is no legality distinct from its proof of execution.
Execution, mere execution will not be sufficient to prove the legality.
What are
Then you have to raise issues of suspicious circumstances, which you never did.
Address your lordship on the
Nothing more. There's nothing more.
After this order, my lord, he has filed a suit for declaration that is pending.
Very well. Let you find that out. If he's now made it easier for you, then why have you filed a suit for declaration, Mr.
Because he can't move it. He can't do
It's
it.
pending, my lord. So that route will.
Having heard the learned counsel.
Better that I don't say anything on it.
We find no ground and reason to interfere with the improved judgment passed by the High Court, especially petitions from the dismissed.
You may say something on the.
Already.
route or-
Nothing more.
Very great.
More than what the testified said in the case.
I don't know what kind of.
Council isn't available today due to some.
Isn't?
Available today due to.
Why? What happened? It's a working day. Where's he gone?
It's an emergency, dental surgery.
Emergency. Matinee show.
Dental surgery.
Dental surgery. When did this happen?
In the morning.
In the morning, he needed dental surgery.
Hello, sir, holding on to my.
Please visit him in the hospital and ensure this is the truth.
Sure. Hello.
Do not wish surgeries and ill health upon yourself for the purpose of an adjournment. There's a God up there. Tadastu.
Hello, so on personal grounds, I don't want to object, but they're holding on to my title dates.
On the lighter side, I remember there was one council in Hyderabad. This was while I was still an advocate. And the learned judge, after being told that the council was seeking an adjournment on a particular ground, he told the council, how many times will you kill your grandfather? I have already granted adjournments on that ground about 5 or 6 times. So how many grandfathers do you have? Or are you killing him several times over? Both ways it is equally bad. So keep that in mind. Adjournment is sought by the learned counsel for the petitioner on the ground that the learned arguing counsel had to undergo emergency dental surgery today morning. Matters according to the judge.
If my lords may keep it high on board.
It will retain its position. The matter is according to the judge based on 7th April. Matter shall retain its position.
Great move. So deeply grateful, my lords.
Article 23.
Was 20. We are led by the senior counsel.
Yes? You are led by whom now?
23.1, Manoj.
Item 23 or 25.
I am in 23.
Learned ASC is on his legs in court one.
No, I am here.
No, my lord, he is there. He is here.
He is there.
Yes, I have my matter before.
Grounds done.
And he's not on his legs, he's on another part of his anatomy.
Who's going to begin? Yes, Ms. Nataraj. Yes, Ms. Nataraj.
The other.
Am I audible? I'll come to the court.
Yes,
come to the court.
So I am I am at 23.1.
Who's in 23?
So this is
Am I audible to the court? I'm sorry.
Yes, Ms. Nataraj, you can come to court or you want to argue from there, please go ahead.
So your counsel is also here.
No, Manoj, I'm afraid.
What do you want?
No, Lord, I'm in 23. Lord, I'm led by Mr. Nadra, sir. And in my case, Lord. Sir, in our case, pleadings are not complete, even though Kalapnama has not been filed.
We are led by Mr. Double AG, Mr. Senior Counsel, Mr. Porter Raju. Mr. Porter Raju, Sridhar Porter Raju. He's on his legs. So also, we wanted to file a rejoinder.
So each of these matters, a different counsel will be appearing.
All my lord raise the same issue.
Same issue. So if Mr. Nataraj can begin, we'll hear him.
In that matter,
I can't see anything.
SG is appealing. They have not filed their reply in this matter.
Who?
Other side, the respondents.
Lord, in main matter, learned ASG is appearing, Lord. I'm appearing in Vista Sales case, Lord, for mining corporation, led by learned ASG, Lord. So he would take the lead, Lord, in this matter.
Vista Sales is there in 2 matters. And in one matter, Param Agency, one is Shishir. And
But I'm in 23.1.
23 and 23.1, the respondent number 1 is the same.
There are various respondents.
That's right. That's right.
Each of the matters respondents array might be, I think,
different.
In 23 and 23.1, the same respondent is there. as number one.
Is a clubbing of about 13 SLPs. They are in.
Or we can put up a
23.1.
SLP, are you appearing for this Vista?
No.
No.
We are
Lord,
not-
learned SG is appearing for the Vista, my lord.
Okay,
Oh.
okay.
Who's
Yes.
appearing for State Mining Corporation?
Yes, my lord, yes.
Who?
I am appearing for State Mining Corporation in first matter.
What is this?
In the second matter,
No, the
second
other,
matter, state is challenging the very same order. However, in the first matter, service is complete, but nobody has entered appearance. In the
Why?
second matter, they have filed a counter. However, we are not parties. We have to file a rejoinder in the first matter, since no counter is filed in the first matter.
who filed a counter? You said no one has entered appearance.
Yes, in the second matter, they have filed a counter. Therefore, we have to file a rejoinder only to the counter filed in the second matter, being a common judgment.
Very good. You're not a party to the second matter, the State Mining Corporation?
No, we are respondents, but
But a
however,
party-
this contesting party is the other party.
So who is appearing for this company here?
Vista Sales.
Respondent number one.
Vista Sales Private Limited, who?
There's nobody.
No, Vista says no, learned SG is appearing.
Vista says they are not appearing. He's a fool. What?
23.1.
The names of the council shown, there's no one appearing for R1.
Megha Karnwal is A1, my lord. Correspondent number one.
Or is it KVAT? KVAT council is correspondent number one.
The 29th April also because.
Maybe
23.1.
because it only says KVAT without mentioning KVAT for whom.
The 23.1 is a bunch of 13 matters. So, my lord, in SLP Civil 6101,
Yes,
Vista Sales will be figuring as first respondent.
yes.
In the same item 23.1, another SLP is 6103, the third of the bunch matters, in which R1, my lord, is Arcade Transport and Construction for who
I
appears.
see you are.
So the same item 23.1 will have 13 matters, my lord, in which respondent number one will keep changing.
Oh, I see. Respondent number one will keep on changing. The other two items also, they're in 23.3, we seem to have 10 matters, 11 matters.
We are not there.
11 matters in that. What about service in the other matters? There's no representation for the respondents in either 23.2 or 23.3.
So then 100%. Service.
Service complete in 11284. 11284 is 23.2. And 23.3. Service complete. Very well. No one appears, so be it.
My lord, I appear for, in 23.1, I appear for respondent number 4 and respondent number 12.
Whoever is appearing because service seems to be complete in all the matters.
If I may just bring one fact to my lord's notice. My lord, in relying upon this order which is before your lordships today, my lord, subsequent orders came to be passed by the High Court against which SLPs were preferred, which your lordships were pleased to post on 7th April. All my lord raised the same issue. This matters could be posted on that day, and if the pleadings could be completed in the meantime. The matter
What is that matter now?
before your lordships.
Oh, that came up separately.
It came up separately because a subsequent judgment, High Court relied upon this earlier judgment. So we came in appeal against that order.
Coming up on 7th April.
7th April.
Are you aware of this matter, Mr. Nataraj?
No, I am not aware. Anyway, I'll take notice of the
Same,
other.
same.
I'll collect the number. I'm not aware of it.
Filed by the state of Madhya Pradesh, the Solicitor General had
State of Madhya Pradesh.
appeared perhaps.
Correct. Then it solicitor appeared in.
Oh, sorry?
This is some different matter.
No, that order relied upon.
This.
Yes. The same issue arises.
Now, today, if you're willing to go on, we've got 15 minutes at least. We can make a beginning. Mr. Nataraj?
Just give me some time because just now I came from the 9 judges bench, so I could not rush to report on
70.
Please.
Your Lordship, I am appearing for 7, 13 and 15, not for 1. I was not unmuted. I couldn't mention it, Your Lordship.
Yes, you went.
I am appearing for 7, 13 and 15 and 23.1.
Very good. If you file your wakalat, then
Yes.
What is not appearing for one?
You're not appearing for one, is
For
it?
one, no, Lordship, I have not filed
Yes.
vakalat for one.
Whoever, because it's, the office report shows that the service is complete. So whoever chooses to appear, so be it.
Obliged.
Obliged.
Also list on 7th April.
Obliged.
Matter shall retain its position.
Item 24. Item 24, I am appearing for respondents 1 to 3, my lords. LIC.
Yes. Counsel for the petitioner is here. Some rule validities.
Diaries of the
Appearing for the petitioner.
Yes.
Your Lordship, notice was issued on 24 November. We were told to file copies for notice, but there is a delay. So we filed a application for condonation of delay of 32 days for filing spare copies, if that may be allowed, Your Lordship.
Oh, I see. You've not filed the spare copy.
No, we have filed spare copies.
With delay.
We filed spare copies on 5th January and we also filed application for condonation of delay.
Notice, no? They won't issue notice.
For the LIC.
I accepted
Number 4, who is responding?
Union of India.
Oh, Union of India.
You are the contesting respondent.
Yes.
Union of India is just pro forma.
Your Lordship, since I am
It's a
under the
rule.
regulation of the Union of India.
No question of.
Yes, but I am the main contesting respondent. I
For the
am
contesting respondent.
counter
We
affidavit.
can go ahead with the matter. Yes, counsel, you can go ahead with the matter.
Came for condonation sitting.
Your Lordship,
We'll condone it, but you can start.
counter has been filed.
Nothing to say.
Your
Not
Lordship,
joined up.
counter has been filed. We may be given time to file a rejoinder.
Delay in filing spare copies is condoned. Registry shall take necessary steps for issuance of notice to respondent number 4. Counter affidavit filed by respondent numbers 1 to 3 is taken on record and counsel for the petitioner. Takes some time to file a rejoinder thereto. Full shall be done well before the next date of hearing. Based on 14th April. Matter shall return its position.
14th April
April.
may be declared because it's
Any-
Ekka Jayanti.
I don't think we have a holiday.
It's
As
end
of now, the calendar doesn't indicate
Very
it.
well.
Last year, was it a holiday?
It is declared holiday after issuance of the calendar.
Every year?
Every year.
Why do they do that? Then this will go for a toss.
14th April, yes, it is.
This last year we had a holiday. Now I remember.
It's only declared at the last minute.
Notified later.
by the
It
Supreme
was
Court.
notified later on.
Every year it is like this.
21st. April.
My lords, can I just request for 22nd then? In that case?
22nd will be a Wednesday again.
Very well, 21st is.
It's all right?
Yes. I'm okay.
Obliged.
25.
Please, Your Lordships.
Yes.
My Lord, we have to impugn judgment. The matter has been remanded back for adjudication to the Original Revenue Authority. Even though the first round of appeal against the decree, my lords, was filed after almost 30 years. And the Honorable Court.
Just give me a moment.
I'm so sorry.
Yes.
Yes. With your Lordship's permission, may I in fact With your lordship's permission, may I in fact hand over a case timeline, because there have been a number of proceedings which happened after 30 years once the respondent.
Council is online. Is that right?
My lords, I'm appearing for respondent number 326, my lords.
My lords, I'm referring to the state, but per se, state has no role in this.
Nothing.
Former part.
Yes.
My lord, so the case timeline, just very briefly, it'll help put things in perspectives. The revenue case, my lords, that was decided in 1975. That's the date of the judgment. That was filed, my lords, by Hariram, who's a petitioner before your lordships. And the suit was decreed in my favor, declaring me to be a khatedar, ordering eviction of Miss Keshi. And the document number is given. My lords, so appeal against that has been filed after 30 years. And it got decided on 31/12/2009. That appeal was dismissed in my favor. Thereafter, my lords, another appeal, we come to serial number 4, because serial number 3 is a different tangent, my lords. That's an execution of my decree. Serial number 4 is where the respondent files a second appeal.
Did you get the possession of the land also?
Always been us.
No, because in your suit you asked for possession.
My lords, so there is a controversy regarding, there is that mention to say that half possession was with them. We said illegally they had been doing that. Half possession was always with us. So as far as
The
we are
remaining half still remains with them.
it's with us, man.
Yes.
No, because the order, even according to this list that you've given,
yes,
the first order required eviction of Keshi.
That's right, my lords.
So did that take place at all?
My lords, would kindly just have page 131. There is a report that was then furnished, which confirmed that possession was with me. Second para, last 3 lines. However, the report also states that the land is not being cultivated at present, and physical possession of the land rests with Hariram.
No, but once you yourself said that I don't have possession, give me possession, the suit is decreed in your favor, ordering the eviction of Keshi, there needs to be some proceeding indicating that there was delivery of possession or eviction of Keshi.
My lords, so there is no proceeding or any order post 1975, but 1975 I'm instructed is when we took over possession. And this report then went ahead in future and confirmed that possession was with me.
Then?
Thereafter, my lords, the second appeal was filed. And the order dated 6/9/2011. This is the Board of Revenue Ajmer. My lords, Revenue Appellate Authority subordinate, Board of Revenue is the appellate over here. And that allowed, that appeal, my lords, set aside the decree and demanded the matter for adjudication. I filed a review which was dismissed. Filed a review which was dismissed. Then I filed before the Honorable Single Bench and then the Division Bench, which all went against me. So first 3 went in my favor, and thereafter continuously I've been losing the matter. But factually what is undisputed, my lords, is 1975 is the decree. 30 years later is the appeal filed. What seems to have prevailed on the Honorable Judges is, and I'll take your lordship's include order regarding that, is that according to the Honorable Court, the lady concerned had not been given adequate opportunities. And the lady is already, unfortunately, no longer there. But what the Honorable Court failed to appreciate, and there's a contradiction within the include order itself, that the court itself said due process was followed, all opportunities were given. The cross-examination happens. There is a order 13, rule 2, application moved to say by the lady that I wish to produce a sale deed, because her claim was that I'm the owner, never produces the sale deed.
She claims that she purchased the property from your mother.
That's right. I'm so grateful. But that sale deed has never seen the light of day, till date. And today the respondents who are there claim that they got into a sale deed with Miss Keshi. And that sale deed is also not before your lordship. So if anything, my lords, if I was to ask myself this question, this would have been the golden opportunity for them to finally introduce the sale deeds, let alone original, etc. Never been produced.
Even now.
Even today. So we are in a situation, my lords, after 30 years.
You have a copy of the sale deed, comes. Your application in that regard was allowed on 2/12/1968. Yes, Council. Council. Council for respond number?
Yes, my lords, we have submitted mutation entry record
Where is
pertaining to the
sale deed?
my lords, sale deed would, my lords, it's 99 rupees sale deed, which was not supposed to be registered because it was below 100 rupees.
Where is
And it
the
was
sale
not,
deed? 5/4/1963 sale deed under which you are claiming. Where is that sale deed?
oh, my lords, so I'm a subsequent purchaser, I will be submitting on record. Because my lords, this case pertained to the KC Devi from whom I had purchased land in 2006. I will be submitting that. That certainly there, my
So
lords.
you're a purchaser, is it not the LR?
Subsequent purchase, I am not KC Devi. KC Devi is no more, my lords.
In fact, even the purchasers, LRs have come into play now. So with greatest respect, my lords, and if you have to go back 55 years now, it's 70 years in fact.
Your predecessor invited an order on 2/12/1968 saying that she would produce the sale deed. Time was granted for that. She never produced it. That is the reason why his suit was decreed long thereafter.
My lords, subsequent to that,
Later, the suit is decreed.
At what stage did you come on record? The subsequent purchaser.
In
2006, my lords. 2006, my lords, what transpired?
From 2006
KC Devi.
onwards, you have not thought it fit to produce the sale deed. You say
My lords, I can submit my sale deed via KC
Mutation also
Devi.
got cancelled, my lords. Their mutation also.
Well, one last opportunity will grant that. Then council for respond number?
326.
326, my lords.
3 to
Yes, my
6
lords.
shall produce the sale deed dated 5/4/1963. The original sale deed dated 5/4/1963 alleged to have been executed by the mother of the petitioner.
Deep lovely.
Blank paper and say that a sale deed was executed on a blank paper. Not happening. If at all you need to manufacture it, go find a 1963 stamp paper now.
Not find a time machine.
So that we won't give you too much time to do that though.
And I will be submitting it, my lords.
Next Tuesday. This next Tuesday. Matter shall retain its position.
My lords want to mention item number 27. My lords, we're seeking 3 weeks time to file my reply. Listed after 3 weeks.
Why do you need 3 weeks time to? If you want time, then we'll post it in December.
Lord, I'm appealing for that.
That is how it is.
Lord, they can file it by the next date of hearing.
Then let it remain in the list. Why do you need 3 weeks to file it?